then I looked at the time. I was like, well, let me go in the courtroom and just come in here. I haven't even got PD forms yet. I don't know, because I came in here. I was like, well, let me go in early so that I can get, you know, everything sent. Nope, nobody's in here. I haven't got the PD form, nothing. So as soon as I get it, if you don't beat me in here, then. Yeah, I saw that too. So I was like, oh, I'm definitely getting the list. But no one has been here. And I haven't seen Dexter today, so. Okay. Yeah, and then I'll see if they, yeah. All right. Thank you. Bye. 2018 and then 1578. Oh yeah, I did get PTC date on one of them, and that's probably the one. Yeah. That's the only one that I gave dates to on these things. For the side. Hey. Or you can just print and put it on my desk. I appreciate it because I totally forgot that I even wrote a court date. Because when you said that, I was like, what she talking about? I don't even remember. And I was thinking session words. I'm like, session words update. So maybe it didn't update. And I'm like, let me just look at it. And I'm looking like, okay. That should be the only one. Those two things, because I was rushing. I was supposed to be in, but it was anything else. So. Just let me know. Thank you. I was just calling back. I said I was just about to call back there.
you doing?
Hey.
There's that.
See, I brought your tin back.
She gave me these. These are Spanish. She just seems to think they'll be this morning, but
Yeah. Do y'all have a? Oh, she got it in her hand. So that's why I was waiting. Thank you very much.
so what do you think? You think people want to get this done this morning? Maybe if we can do, I don't know, because, I don't want to disrupt anybody's routine or anything, but I was thinking about it being New Year's Eve, probably,
I'm here all day, so.
it doesn't matter.
Look, maybe everybody else has something else, but.
Yeah, because if they want to do that, I can probably make that happen. This is not much. It's not too bad. We can probably knock it out this morning. Question is, do I want to spend all that time at home, or would I rather be here doing this? Well, we'll figure it out. I'll
Just
take
let
a
us know.
poll when
All
I come back.
right, let me
Okay.
know. Who's the other one? Hey. Oh, no, he's fine. Of course they gave me the list when he brought the stuff in there, which I knew, and then I see the email. I was like, I knew it was gonna happen. I was like, I knew it. I was like, yeah, they added like 2 more Spanish, and then they added 3 new ups. Yeah, I'm doing all the. Did you move everything up like we did yesterday too? Okay, I thought so, because I'm looking at it, I'm like, wait a minute. I'm like, I actually have all of this stuff. Okay. Yeah, because I see the missing subtracted, because it wasn't that much of that this morning. Yeah. Yeah. So I'm going to take those out. I'm pulling his stuff out now. Okay. All right. Thank you. I can't stay away. morning. Hello.
Hi, Detective Ramirez. This is Edith Bush again. I just walked into the courtroom. This case is going to be called this morning because he says that he needs an interpreter. So what I can do two things. I believe I have a strong argument to modify the bond, and a strong argument that this is just a Scribner's error, and I should be able to get the bond reset, and I should be able to show beyond a reasonable doubt that the date of the offense was after he was placed on bond. I have to double check that because I don't know when he was placed on bond. And so the date of the offense has to be after he was placed on bond. So those two arrests that he's out on bond on have to have occurred before March of this year. Yes. And I'm looking at it and I'm thinking that on the 26th of March, so that means that he wasn't put on bond until 2 to 3 days after the date of the murder. Correct. But the issue is to disturb the out on bond. They have to have been placed on bond before the actual criminal act. So I may not have any argument to have his out on bond revoked. I mean, I can give it a shot, but it's not a good faith shot, so I'm not going to give it a shot. If he was placed on bond a few days after, or released on bond a few days after the murder, I can't revoke his bonds. Oh, I didn't even realize that. Hang on. Anyway, let's just keep talking and I'll handle that in a minute. Let me get rid of this. Hold on. What in heaven's name? Okay, let's see if that works. Okay, so I'll let you know what happens. I think I can still get the bond upped. I don't know that I can get it set at no bond, but I might be successful in doing that. I have to see what kind of other history he has. He actually has no convictions yet. Okay. Then we don't have Puerto Rico's convictions. We just show that he has no out-of-state convictions. We show that he has out-of-state arrest history, but we don't know what the actual history is or what the disposition of that history is. But I'll do what I can, and I will let you know. But in the meantime, still try to get a corrected warrant through. Okay? We start in 2 minutes, and our interpreter list is the first up. So it'll be in 2 minutes. It'll be in about 15 minutes, and there's no way you're going to get here from St. Cloud. Okay, all I'm saying is do the due diligence that you need to do to get it corrected, regardless of whether it's corrected by the time court starts or not. I'm not expecting it to be corrected by the time court starts. I'm gonna do my part and argue for it to be corrected before court starts.
Yesterday she started right here, but the other day she
So.
started like right here.
Because I'm calling you from the courtroom right now. Okay? All righty, bye-bye. Good morning.
Good morning.
Can you all tell me when, good morning, when Joel Nieves Sanchez was placed on, or was released on bond? I've got a funny feeling it was after he committed this murder, but. And I have no idea why this judge gave him a $5,000 bond for a murder.
Oh, man.
Really?
There is a typo, not in the affidavit to issue the warrant. The affidavit to issue the warrant says March 24th, 2020. In the actual warrant, it says March 24th, 2010. But that shouldn't matter. It's murder. You don't give a $5,000 bond for murder.
Right.
And he still didn't bond?
He got out on May the 2nd,
Oh, he bond.
last time.
Oh,
He was-
nice.
Okay, so on his drug charges, it was May 2nd that he bonded, right?
Yes.
So, he committed the murder March 24th, so I can't even get his bonds revoked and get them set at 0.
Wow.
Somebody from the jail called this detective early this morning and said, somebody named Officer Williams called and said, listen, this could affect his out on bond and it's a $5,000, and we see where the problem is. The warrant itself says that the crime was committed in 2010. But everything else supporting that warrant shows it's just a Scribner's error. It's a typographical error. Somebody hit a 1 instead of a 2.
Right.
Morning, everybody.
Good morning.
Morning.
Aguilar.
What's up, big dog?
So, ain't no big no. I'm just old school. That's it. Old school. You know, my son.
Hi.
That's how I see my son. He said, "Oh man, what's cooking?" I said, I'm just easy like Sunday morning.
How old is that?
I got 3. I got 22, 29, 30.
They ball?
Just one ball.
Oh.
And one crazy about, video games.
Yeah.
Yeah,
Be like that, though.
yeah. Just one ball. He's 7.
Wow.
Yeah. And my daughter, 16.
Your daughter?
All 4 of them.
That's,
They just pretty big to be.
my mother is 6 foot, my sister's 5'11". But my dad like 5'10", so
Oh,
that's
they
why
put that hold on him.
I'm on the shorter side.
No, the detective
Wow.
hold.
Wow.
Good morning.
Size 13. Try dressing her.
She can wear my shoes. I know I wear 14.
Yeah, my husband is a size 14.
Yeah.
How tall is she?
6'2".
My husband's 6'5.5".
Oh, yeah.
Okay.
My daughter's 6'2.5". Then my eldest daughter is 5'1", 1.5.
Yes, all
And then my son is right at 6'1".
600, yeah.
Yep. I go from Munchkin to Giant
Yeah, then back down.
to Norm.
Yeah, no.
And the reason my eldest is as short as she is, and she's shorter than I am, is because her dad is smaller than I am. That might be why I just have a lot of disdain for what I call petite men.
Yeah.
Well, they all have a Napoleon complex anyway. And they want to be bigger, badder than the next person because
Yeah.
they're trying to compensate for their
Yeah.
petite.
Yeah.
When we were in quote-unquote show business, he could get into my clothes, for Pete's sake. And my clothes were a little bit, and I was all of 98 pounds. He was a tiny man. Still is a tiny man.
So we have a 3rd-degree felony murder.
Yep.
That's not a PBL, right?
You know, it could be punishable up to life. It's not a PBL, but it might be punishable up to life. And I don't see how Judge Weiss gave it a $5,000 bond.
I don't like.
That bond has to be changed.
Even like the bond for yesterday with the DUI manslaughter, I'm like,
Yep.
these are some low bonds for homicide, you know?
5,000.
So be on the record.
Oh, yeah, we are. Oops. But, yeah. We don't have radio on. The radio helps muffle a lot of what's said in the courtroom.
So Edie,
It's an F2,
that's wrong.
but it should still be, let me just see what the bond schedule is. It should still be,
So Edie, today is your last day, right?
no, Monday is.
Okay, I thought you said Monday. So you'll be in here on Monday?
Yep.
All right.
With a firearm makes it a life felony. Okay. So.
Okay, oh, okay. Need to keep straight. You know it's hot.
Okay, yeah, that was it. But it was kind of quick. Is it on? B, can you get that back to the PD, please?
You sign it?
Yep.
Oh, no. I thought. I remember last time I was here, a guy told me that they don't read them and they just throw them way back there. So I'm like,
I say that, I just say go. Yeah. Yeah. Yeah.
Thank you.
you know, Dexter had the papers in here. Yeah, he put out a bunch. He put out a bunch in there.
Hey. Can't be going to nobody's house, man.
I know, right?
Yeah. I should have been walking. I hate to get
See, this should actually be murder in the second degree.
Oh, but you know, I'm not gonna, I was always gonna contest it, but it's kind of. Yeah, that's good.
Yes, definitely do. Love you. Have a blessed 2021. Have a blessed. Well, we all feel that it's got to be better. It can't be any worse. 2020 was
Oh,
it's time to put 2020.
oh.
We can't put it all behind us. We don't want to put it all. It was just, no.
What kind of porn? Yeah, I guess so. I mean,
Get it.
usually they're just on the front desk and I pick them up. I've been out. Well, yeah, you go see. I think last time I checked, there wasn't. All right.
You already did.
And he
You
has,
went over it. Go ahead and look it over.
at the rap on this guy. The detective says that he's a convicted felon out of Puerto Rico. And we show no dispositions for his out of state.
Oh,
But the rap should be said, including some sort of lascivious behavior with a child.
I know not to leave you in charge.
And I do see on our first appearance information sheet,
But that's the only one I see.
that just looks like domestic violence to me. It says conjugal abuse.
It's the
I think that's more domestic violence. But he also apparently was in a correctional facility. And I just I don't wanna say something just because somebody said it to me.
Right.
Oh, what's his name? What's his name again?
His name is
I got the wrong person.
She said,
Joel Nieves Sanchez.
courtroom. I didn't know it ain't. It's go by post.
Well,
You know,
he got out on bonds.
Yeah, I know. No,
But you
but
wanna-
I'm
Oh,
talking
okay.
specifically about his criminal history
History.
so that I can make a valid argument to change a murder charge from a $5,000 bond to a reasonable murder charge.
you know what? Well, I'm gonna be starving, so I'm gonna.
Are we talking about the same person? Somebody must have did something. What's the booking number? 8442? They had to because it was right here. Somebody must have took it out.
They took it out completely. They didn't close it out. It's like it's non-existent.
Oh, okay, they just gonna have to get a conversation. Yeah, it was in here. 8442?
But you see, they never. All right. When you go in there, it's like they never put it in because it's not even rated. Like,
It had to be a supervisor.
Do you all have somebody named Williams?
Mm-hmm.
we do.
Well, apparently that's the person that called the detective.
So what was your question again, Ms. Bush? What did you need to
If
know?
you see any history out of Puerto Rico,
I do.
do you see any dispositions or is it just unknown?
I
Because
just see it's conjugal abuse,
times more.
again, for another year, dangerous drugs. He was in a Zarzell correctional camp and another conjugal abuse. That's it.
So, but the Puerto Rico stuff, like in the US, the rap sheets oftentimes will show what the ultimate outcome was, whether
Yeah.
or not they were adjudicated.
No
We can't-
disposition.
Okay. But that might give me a little something. He's got violent crimes in his history. In Puerto Rico. The conjugal abuses. I'm guessing at very least it's domestic violence.
Somebody must have took it out, 'cause like she said, the warrant superseded this. So basically, it's not on the bond, but somebody did put these payments right there.
Even though the detainer should be there, regardless of when, and because the judge, every week you hear the judge say, I am taking no action because this preceded,
Right,
so,
right. That's just for me.
so,
CYA purposes, that's why I'm like, why did y'all take, you know, completely out? Yeah.
and it shouldn't have been taken completely out.
Right, I would have rather just closed it out as, you know, as we
Entry
did
error,
entry error or prestige, whatever, than to not. Because when they get a bond now, you get what I'm saying? I don't want him to walk out. Like, he's supposed to be out, but I have to delete myself.
Well, here's the thing. I can't use those, however, the facts of those cases are contained, those cases occurred, the facts occurred before the murder. The murder actually occurred on the 24th after all of this happen. It was all a flub. They found the drugs, they found the gun,
Okay, and it led to.
and then later, they killed him.
All rise.
Did you get it?
Yeah,
Did I give you that card?
this is a drug deal gone bad.
That's your point of order.
Or,
The
Thanks,
ultimate,
have a seat, sorry.
they're drug dealers,
yeah.
but.
Y'all probably needed the exercise anyway, right?
Right. That wasn't paid. They were also stealing cars and selling cars.
Huh? What?
Yeah.
Sometimes it automatically. I don't really touch it.
The one that did the shooting,
Any Gator fans in here?
Also not this guy.
they were together.
Okay, we're on. So, let me get appearances for the record. State? Oops, need an appearance this morning.
Good morning, Edith Bush for the Office of the State Attorney.
Chase Thompson on behalf of the Office of the Public Defender.
Thank you both. And we got a couple of move-ups we're going to deal with first. Looks like the first one's Jason Andrew Feeney.
He's behaving, young.
Behavior. So, now, remind me again, what are we doing with behavior cases?
They're viewing it as a voluntary waiver because of the client's inability to attend court.
A waiver of appearance by the court.
Yeah, I'm comfortable with doing that. Will that also include an appointment of the Office of the Public Defender?
Yes.
Okay, thanks. So Mr. Feeney is not present as a result of behavior, and so the court's going to treat that as a voluntary waiver of his right to appear at first appearance. I am going to appoint the Office of the Public Defender to represent him temporarily and indicate that I find probable cause in the affidavit. His bond is going to be set at $1,500. He's going to be ordered to have no contact with the victim. He's to maintain a separate residence from the victim, consume no alcohol, no drugs not prescribed for him by his own physician, to have no weapons on or about his person, any weapons that he owns or regularly has access to are to be turned into the Orange County Sheriff's Department. Receipt that he receives is to be filed with the clerk's office. He's also not to return to the, get my address here, at 2327 Caborn Street as an additional condition of release. Now, anything else the state requesting in that case?
No, Your Honor.
All right. Mr. Public Defender, he's your client. Anything else you need me to do?
No, Your Honor, but I got another email that's saying that we need to put the case numbers on the record.
Oh, the case number, yeah, thanks. That's probably a good way to start off by doing it right. 2020 MM 9225, Division 50. Okay, next one is Anki Lamb.
Yes,
Did I say any of that right?
you did it perfect. Never
Huh?
happens.
Perfect. You know, I heard a thing on NPR this morning that struck me as kind of funny. You know that when you're in the hospital or you're at the doctor's office and there's some kind of pain associated with whatever it is, and they say, well, on a scale of 1 to 10, what's your pain level? And this lady was talking about it, and she said, and so I told the nurse, she had apparently had a wreck on a bicycle, and she said, it's like an 8. And she said, the nurse looked at her and said, that's a gunshot wound. You want to try again? Well, why'd you give me the scale then? You know, to me it's an 8. But they're right, because I saw that happen with my wife recently when she was asked about her pain level, and she said, she always says 8 or 9 or something. And the nurse didn't say gunshot wound, but she said that's like having a limb involuntarily severed or something. I said, well, you need to change the questions you ask, I think. So, Ms. Lamb, you're charged with battery, and it's alleged to be a domestic violence battery. Do you understand that?
Yeah, I just pushed my husband's neck. That was it.
Okay, you don't want to talk about it. What you don't want to do at this point is talk about the facts of your case, all right?
Okay.
I see from the affidavit that you filled out that you qualify for the services of the public defender. Do you understand that?
Mm-hmm.
Okay. I guess we don't have a victim present?
Yes.
We do not, Your Honor.
Okay. Well, I read the affidavit, and based on the affidavit, I do find probable cause for the charge. I am appointing the Office of the Public Defender to represent you. Now, it says here that you qualify for what's called pretrial release, but I don't believe you can get PTR release unless there is a victim present to consent to a non-monetary form. So what I'm going to do, finding probable cause, is set your bond at $500. Now, I am going to order that you're to have no contact with the victim. You're also to maintain a separate residence from the victim. You're not to return except for those reasons that I'm going to delineate for you to the property located at 12422 Holly Jane Court as a condition of release. You're to consume no alcohol, no drugs, not prescribed for you by your own physician. You're to have no weapons on or about your person. Now, I am going to authorize you a one-time trip back to the Holly Jane address to recover your personal items. And that will be in the company of a law enforcement officer. So that's probably in the county. So you're going to contact either a police department, if there's a police department that has jurisdiction there, or the sheriff's department, and arrange to go back there and have an officer accompany you to pick up those personal items. Do you understand?
I don't have any place else to live.
Huh?
I don't have any place else to live.
Well, ma'am, Florida statutes say what they say about these cases, and what I just dictated to you is pretty much tracks the law in the state of Florida at this stage of the process. But you can talk to your lawyer about that later, and your lawyer can tell you what options you have, okay?
Okay.
All right.
Thank you.
You're welcome. Good luck.
I can't see.
Huh? Yeah.
So know what I do now.
Yeah. I don't believe the law permits it. I mean, that's something I've pursued under for a long time. I'm always open to being told I'm wrong. No, I can take it. Some people just can't bear being told that they're wrong. I get told I'm wrong too often, so you gotta remember, I live with my wife and 2 daughters, and they delight every day in telling me that I'm wrong. So, about little bitty things. Okay.
Did you say, surrender weapons? I know you said it in the first, but I didn't hear it.
No, I didn't.
Yeah.
There's no indication of weapons in there. You got my blue pen over there? Where you go? Oh, there it is. Thank you,
Read
man.
it also.
There we go. Let's see, next case is Sidney Leroy Johnson. Is that you, sir?
Yes, sir.
Okay, I'm gonna need you to speak up just a little bit, okay? All right, sir, you are... Well, it's an out-of-county warrant that's being held on, looks like Suwannee County?
Yeah, but it's out of Orange County.
Stop, wait a second. And the warrant orders that you be
Okay.
held no bond on this out-of-county warrant. Also notice that you're on probation. You are a violent felony offender of special concern.
This is on probation.
So, now you do qualify for the public defender locally, for local purposes. And if I understand the system, y'all correct me if I'm wrong on how this is going to work. What's going to happen is we here are going to contact the court in Suwannee County to find out if they're going to transport you back up there. Am I right so far?
Yes, Your Honor.
Okay. And if for some reason that they're not going to, then your case will be readdressed because you'll still be here being held on no bond. You understand? Yes?
All right, yes, sir.
Okay. Well, good luck.
Does he have reporting requirements?
Yes, Your Honor, he has
Yeah, it looks
reported.
like he has reporting requirements. When you get out of jail, sir, you have to report this arrest as a change of address. Do you understand that? Well, he seems to be otherwise occupied. All right, thank you, sir. Good luck. Odd. That was some odd behavior. So, this right here, these are interpreter cases? Okay, moving right along. Well, we gotta get the interpreters on the line, don't we? Am I gonna have to mess with that white screen again, or can I just push this one?
Tap it.
Tap the screen?
Yep. And then call.
Call. Interpreter.
And then hit call again.
Hey.
Good morning, Your Honor. This is Adam Figueroa, Assistant Vice President Interpreter.
Good morning, sir. Can you maybe crank up your volume just a little bit?
Will this work, Your Honor? Does it sound better?
I can't make out what you're saying. I'm sorry.
Let me just hang up, Your Honor, and just try dialing back real quick.
So hang up and then try again.
Does this issue arise often?
Yes.
Okay, I'm gonna file a complaint. Wonder who I complained to. Because between the masks and this,
It's rough.
it kind of makes it frustrating, doesn't it?
Good morning, Your Honor. This is Laura Arroyo, State Certified Interpreter.
Well, I
Hello.
can hear that. Okay, well, good morning. How are you?
Good morning, Judge Brewer. How are you?
Pretty good, pretty good. I'm much better now that I can hear. This, you know the layout down here, right? There's that big air return here in the courtroom, and then
Yes.
printers running. And I
agree.
I noticed yesterday that I might have heard every third word that was said on this system. And I think everybody in the courtroom is having trouble hearing it. It's apparently an ongoing problem. So I'm not sure what I'm gonna do. Probably walk out of here at the end of the day and forget about it. But being Sam will be back next week, I'm gonna see if they can do something about that. You know, it'd be kind of nice if we had y'all down here again.
I like this.
Well, I understand that y'all like it, but be nice to see you and be able to hear you too.
Well, it's nice to see you, but you can come this way. You can come to downtown courthouse.
Thank you very much. Yeah, have you been sworn today?
No, Your Honor, I have not.
Okay, Madam Clerk, would you do the honors?
Do you swear to translate from Spanish to English, English to Spanish, truthfully in these matters here today?
Yes, Laura Arroyo, State Certified Interpreter.
Thank you. Okay, let's see. First case is, well, let me give you a case number here. It's 2020 MO1367AO. It's Carlos Shamul Aguilar.
You bonded, Your Honor.
Bonded, got it. Next case number is 2020 CF 14634AO. And the name is Angel Herrera.
Yes.
All right. Mr. Herrera, you're being held on charges of burglary of a conveyance, grand theft third degree, dealing in stolen property, and receiving money from a pawnbroker by false verification. Do you understand those charges?
See?
Yes.
All right. This is pursuant to an arrest warrant that was reviewed for probable cause and signed by a judge downtown. That judge, having found probable cause for each of the charges, initially has set your bonds at $2,500 as to count 1, $150 each as to counts 2, 3, and 4. And now I'm looking at an affidavit of insolvency that you filled out, and it appears that you qualify for the services of the public defender. Do you understand that, sir?
Yes.
All right. So I'm going to go ahead and appoint the public defender to represent you. Now, interestingly enough, it also says that he qualifies for pretrial release. So, am I correct on that?
Yes, Your Honor.
Nothing's changed about that?
No.
Okay, thank you. So, counsel, want to make an argument on that?
Yeah, I have no objection to a pretrial release, Your Honor.
I
I have no objection to pretrial release.
What says the state?
Your Honor, he has no disqualifying conviction history, and he has no failure to appear history. The state can't argue against it.
All right. Well, pretrial release is a monitored form of release, sir, where you'll be checking in on a regular basis. It'll all be explained to you back there. You have some paperwork you'll need to sign about it. So you have the bonds, which could be posted, or you can go with pretrial release. If you decide you want to go with pretrial release, the court's going to authorize that, and you're going to be ordered not to return to the location of this incident, alleged incident. Let me get an address for you here. Well, not to Familia Pawn and Jewelry located at 4205 Curry Ford Road. Huh? Home or work? It's very specific, isn't it? Let's just go with don't go back to the pawn shop, okay? All right. So, do you understand all that, sir?
Sí.
Yes.
No, just that familial pawn shop on Curry Ford Road. All right. Well, good luck then. Thank you.
Your Honor, are you releasing him through pretrial release?
I didn't hear you.
Are you releasing the defendant on pretrial release?
Yes, I'm
Okay.
authorizing his release on pretrial release. Straight PTR.
Okay, thank you.
All right. Thank you, sir. Okay, next case number is 2019 CF 2741AO. It's Division 17. Louise David.
Mogollón. Mogollón, Ávila.
Mogollón?
Pero lo escribieron mal.
Is that you, sir?
Sí.
Yes.
All right. Well, you're being held on a failure to appear in Division 17. A capias was issued on August the 6th of last year when you are alleged to have failed to appear for a pretrial conference in Division 17. That court has issued a capias and ordered that you be held no bond on the failure to appear. Do you understand that? Now, did you have an attorney in the case, PD?
Yes.
Okay. The public defender was previously appointed to represent you. They still represent you in the case. That's who you're going to want to talk to now, okay?
Okay.
All right.
Okay.
Good luck.
Also, Your Honor, can you advise him that he has an immigration hold?
He does have an immigration hold. You do have an immigration hold, sir. Do you understand that?
Sí. ¿Puedo decir
Okay.
Yes. May I say something?
You're going to want to talk to your attorney probably before you talk to me or anybody else. So, why don't you go ahead and tell your attorney what it is you wanted to tell me.
Ok, supe de la...
What? Is that a domestic? No, that's, yeah. Okay, next case number is 2020 CF 15079 AO, and seems to me like there was a second case number in there. Yeah.
Your Honor, this client has private counsel representing him on his out on bond charges. I want to know if we could ask him if he intended to have the same counsel on the new charge.
Well, I heard you say you had private counsel. Who is private counsel?
He has Mr. Ramjuan representing him on the out on bond. So I wanted to know if he was going to have the same attorney represent him on the new law, because if he is, we could roll this case to have that attorney.
We have a notice.
I don't know what he wants to do.
From the attorney.
And Your Honor, his,
Yeah.
I'm sorry, counsel, your voice has disappeared.
Okay.
and Your Honor, the out on bond cases all stem from this case that's before the court today, and Mr. Ramjuan does represent him in the out on bond cases.
Well, he did fill out an affidavit of insolvency for this case, and he does qualify for the public defender.
Okay.
So I'm going to go ahead and appoint the office of the public defender to represent him. Do you understand that, sir?
Okay, entendido.
You're talking to me, sir?
Yes, I did understand quite well.
Okay, thank you. Now, according to the warrant, the charge is third-degree murder. Do you understand that?
Entendido.
Understood.
All right. And again, this is pursuant to an arrest warrant, duly reviewed and signed by a judge with jurisdiction over the case, who found probable cause for the charge, and the warrant sets your bond at $5,000. So, State, I suspect you might want to be heard on that.
Yes, Your Honor. And the state would ask the court to take into consideration the facts that are contained within the affidavit to issue the warrant. The facts
I was
that-
just handed the affidavit before I came in here.
Yes, Your Honor.
And it's fairly lengthy. I didn't have a chance to review it in detail. So why don't you give me a Reader's Digest condensed version of what's in that
A
warrant?
Reader's Digest condensed version is that there were multiple drug deals and vehicle sale deals that transpired over a course of time. And leading up to the date of the murder, which was March 24th of 2020, the cases that are now listed as out on bond, the drug cases, those events occurred leading up to the day of the murder of March 24th. On March 24th, 2020, it is alleged that a decision was made to kill the victim. One party said, "Don't kill the victim here because your child is in the home." They took the victim to another location and killed the victim, and it is alleged that the defendant then turned the victim over with his foot and fired more rounds into the victim to be sure he was dead. That is essentially the Reader's Digest version of what I read within the affidavit to issue the warrant.
So, leading up to all of that,
there were drug deals.
What role is this gentleman's?
He was the possessor of the drugs, he was the distributor of the drugs, and he is the person that is alleged to have pulled the trigger.
Okay.
And-
Initial.
I'm sorry?
He was the initial shooter, and then he was the follow-up shooter, both?
No, Your Honor. He was, according to the affidavit, he was the shooter. And I apologize, Your Honor, I have to go back to He was the initial player in the drug charges, and he was the initial shooter. A witness described him as being armed with a black gun with an extended magazine, and described him as holding the victim on the ground at gunpoint and asking for payment, allegedly payment for a car, allegedly. And it's confusing because the final paragraph of the affidavit says that the victim was killed by a person other than Joel Nieves Sanchez. And that is confusing because everything I read indicated that Mr. Sanchez is the person that pulled the trigger.
Well, I looked in there to see what judge reviewed it, and not that one judge is better than another judge, but some judges are more conservative than other judges. In this case, it's Judge Wooten, and I've known Wayne Wooten almost since he was, I probably shouldn't say how long I've known
him. A baby prosecutor.
For a long time. And I've never known Judge Wooten to be anything but conservative when it comes to these things. So Judge Wooten had, at the time he signed this warrant, the officer or officers there to talk about the facts of the case.
Yes,
he apparently is familiar with it from some of the earlier work in it. And for whatever reason, he decided to set a bond at $5,000.
And Your Honor, I also saw Judge Ashton's name
Another
in the
conservative
affidavit.
Judge.
And the detective said that it was Judge Weiss that signed the arrest warrant.
Well, it's Judge Wooten's name. Let's see, there's the affidavit where they typed in Judge Wooten or Judge Weiss's name, and then the affidavit for arrest warrant where they typed in Judge Wooten's name.
Yes, Your Honor.
I don't see Judge Ashton's name in there anymore.
Judge Ashton's name comes up within the body of the, and he may have been, because this affidavit encompasses the two prior arrests for the drug charges. So this seems to encompass all of the events, including the murder, Your Honor. So it was a bit confusing, but it did have Judge Ashton's name contained within. I don't know if he signed one of the other affidavits or not.
What I would be willing to do at this point is add GPS monitoring.
We do not have that in Orange County, Your Honor.
We don't?
No, Your Honor. We have not had it for a number of years.
Help me out, counsel.
Your Honor, I tend to agree with you. We had the judges who had the option in front of them to talk to. For some reason,
I'm sorry to interrupt. Something must be happening with that microphone. The attorney's voice is breaking. If you could go back to the other microphone, it was working fine.
Your Honor, we had the judge with the officer in front of him for them to talk and ask questions about the case. He set the bond at $5,000. I think it should remain as set. Typically down here, we don't disturb the judge's ruling when it comes to particular warrants. Now, in this case, the state has ample opportunity to file a motion for pre-detention if they choose to do so, and they could do that at that time. And this could be taken up in the trial division. I recommend that we just leave everything as is.
And Your Honor, normally it is true, except in this instance, the warrant says that the first appearance judge could set release conditions and terms. And when that is in the warrant, then the first appearance judge can make a decision on bond, on release conditions, and the terms of those conditions. And it does appear that Judge Ashton signed the search warrants that led to the subsequent arrests. And Judge Wooten was also involved in this. However, the state's argument just goes to that $5,000 amount for a murder charge. And
So you're not asking this court to no bonding, you're simply
Your
asking
Honor.
me to kick it skyward?
Your
as far as the
Honor,
bond is
yes,
concerned?
and I'm asking the court to take into account, though his bond dates were subsequent to the murder, the cases that he was arrested on, that he bonded out on previously, those all preceded the March 24th murder. And in addition, he has Puerto Rico criminal history, which includes crimes of violence, conjugal abuse ×4, dangerous drugs, and he also spent time in a correctional camp in Puerto Rico. The state would ask the court, based on the safety of the community and based on his criminal history and the violent nature of his criminal history, to set the bond in this matter at $100,000 with no contact with witnesses, victim's family, possess no weapons, firearms, or ammunition, and if there is a passport, to surrender the passport. And that would be the state's request, Your Honor.
Can I be heard, Your Honor?
Go ahead.
Also, I do see arrest history, but I'd like to point out that he wasn't convicted of any of those charges. As it stands, he doesn't have any convictions. He has no failures to appear. Like I said, in the arrest, in the probable cause supporting document, there seems to be a discrepancy. There seems to be one half saying that he was the shooter, and at the end it says that the alleged victim was killed by somebody other than my client. Like I said, the judge set the bond at $5,000. I believe that he probably did so for good reason. I believe that they were probably privy to facts that we are not privy to at this point. I would say that this seems to be complicated, seems to have some kind of discrepancies involved. We should let this be handled in the trial division, and we should keep the bond at $5,000 as it is. If the judge who signed the warrant wanted my client to surrender his passport, he would have put that in the warrant. None of that's in there at this particular time. I'll just say that we handle this downtown, Your Honor.
Well, let me address all those issues so that if anybody's going to be angry about what I do here today, they'll know exactly what to be angry about. First of all, raising a bond to a much higher amount is a bit disingenuous. It doesn't protect a community to give him a higher bond. He makes the higher bond, he's still in the community. Raising the bond to an amount that potentially he couldn't make is tantamount to holding him on no bond, all of which has been addressed by the appropriate appellate courts, and they frowned seriously on that.
Yes, Your Honor.
Coming back to the fact that at least 3 different judges have had their hands on this before it got to me, all 3 of which I respect, their knowledge, their opinions, how they deal with these cases. I'm not inclined to disturb what they've done because I believe, based on the information I have in front of me now, that they too saw the inconsistencies in these warrants. And rather than sign a no bond warrant initially on a murder charge, which, come on, it's a 3rd-degree murder. It's serious, really serious. But under the circumstances and under Florida law, he would be entitled to a reasonable bond. And at the point this warrant was reviewed, the judges had an opportunity to speak to the officer or officers who presented the warrant. They made an informed decision to set his bond at $5,000. So I will deny the request to raise the bond. We'll leave it at $5,000. I realize apparently you're from Puerto Rico. You don't need a passport to come to and from the United States. But if you do have a passport, I'm going to go ahead and order that you surrender that passport. So bond is $5,000. No contact with any state witnesses. No weapons on or about your person as a condition of release. Any weapons that you own or regularly have access to, you're to turn over to the Orange County Sheriff's Department within 24 hours of your release from jail. And as I indicated earlier, if you have a passport, you are to surrender that passport. Okay? So that'll do it. Thank you. This hearing's concluded.
And Your Honor, just for the record, the court is not taking any action on the out on bond because they are.
This is all one, that was another thing I meant to address. It appears to be one fairly lengthy, contiguous transaction, the earlier charges and this charge. So I don't think it would be appropriate for me to revoke his bond on the other cases that he's already bonded out on, that are a part and parcel of what's alleged here. So, thank you.
Judge,
Good
did you
luck.
put that in the paperwork? Because I didn't receive anything from inmate records regarding the out on bond stuff.
You can put in there no action on the cases he's out
I
on
would
bond.
need a case number, all the case numbers for the cases that
How
he's out
about
on
no
bond.
action on any cases he might be out on?
Madam Clerk, do you need? I'm guessing you don't have the same first appearance sheet that.
No, she doesn't have the case number.
Okay.
Why don't you just come up here and give them to her? So apparently there are a few.
There are two. Yes, Your Honor.
I still need those stamps.
Good argument, though.
I still need those stamps for the record.
Well, I knew I couldn't make the argument that by reading the facts and looking at the statute, it's actually a second-degree murder, but.
Right. Sometimes you're stuck.
And it truly was not intended to be I had received an early call from the detective and
Right.
from corrections personnel and.
Well, you know, it's kind of like that game that our president loves to play. You just got to play it the way it lays.
And it was a belief that the warrant, because it had a typographical error in it, might have led to the $5,000 bond because it said 2010 instead of 2020.
Yeah, you would think somebody would have addressed that prior to today, but
Yes, and,
you know, we'll just
and
play it the way it lays.
I got that call at 7:40 this morning.
All right, thank you.
Thank you.
Let's see, next case is, look at that, CT 190068331. Goodness, that's like a trillion. LD. And it's Miguel Suarez. Is that you, sir?
Sí.
Yes.
All right, sir. I have a out-of-county warrant out of Polk County, which says you failed to appear on a DUI and a no valid driver's license. And Polk County has ordered that you be held no bond on those failures to appear. Do you understand that?
Sí, pero yo fui a la corte porque mi abogado no me dejó saber. No fue
It's a
cosa mía.
yes or no question, sir.
I'm sorry, Your Honor. I'm going to ask him to push his mic on his headset back. It's causing an interference. Correctional law. No, it's actually, the other mic is much better. So if we could just push the mic from the headset away. Thank you.
Que yo fallé a la corte porque mi abogado no me dejó saber.
I missed that
Y
court
yo me
appearance
tuve que
because
buscar renta en otro lado y no me llegó la carta a tiempo.
my attorney never informed me of that appearance, of that court date. And also, I moved and I didn't receive the paperwork at my new address.
I'm appointing the public defender for you locally. You have filled out an affidavit. It does indicate that you qualify. Now, here are the steps we're going to take. We're going to contact Polk County and ask them if they're going to come and get you. And if they say they're not going to transport you, then you're going to have a local attorney advocating for you here. You will be brought back to court so we can talk about potential conditions of release on these failures to appear. Do you understand?
Sí, porque le digo, ya llevo desde el 15 de marzo y estuve trabajando también en Tampa y mi abogado no me estaba ayudando. Hasta apenas ayer lo vi. Fui arrestado.
I've been arrested since the 15th of March, and I've spoken to my attorney. He's disappeared, and I didn't get to speak to him until just yesterday.
Okay. Counsel?
Okay, está. Ok, está bien, porque la otra vez me pusieron uno, pero no vino a verme. Porque... Sí, porque el que tengo personal, él apenas lo vi ayer, desde el tiempo que estuvo arrestado.
All right, thank you, sir. Good luck.
Thank you.
Madam Interpreter, I think that's the last interpreter case that we have.
Thank you, Your Honor. I will disconnect.
Hey, thank you. It was nice
Have a
to
nice
hear
day.
from you.
Likewise.
Have a good New Year.
You too.
Bye-bye. Huh. Okay, let's see. Madam Court Reporter. Case number on the next case is 2020 CF 15334AO. And case is assigned to Division 22. Genesis Shamia Fisher. Is that you, ma'am?
Yes.
Okay. You're charged with aggravated assault with a firearm as an incident of domestic violence. Do you understand that charge?
Yes, sir.
All right, you have filled out an affidavit of insolvency. You do qualify for the public defender. And I did review the affidavit. I do find probable cause for the charge. Bond is going to be set at $1,500. Now, you're going to be ordered to have no contact with the victim or victims. You're to maintain a separate residence from the victim or victims. You're not to return. Oh, goodness, where are we at? To 218 West 19th Street here in Orange County, Florida.
That's where I stay at.
Pardon me?
That's where I stay at.
And Your Honor?
Yeah.
The state is showing that a different address for the victim.
Would that be 148 West 19th Street?
No, Your Honor, it's a Grandview Drive address.
Yeah, let me see. A lot of addresses here. Give me that address.
Your Honor, does the court have the witness form of the affidavit? I hesitate to put the victim's address on the record as it's being live streamed. Your Honor.
Oh, wait a second. Here we go. I do have it. Um, I see two different addresses. Okay. Um, all right, that's the one she's going to. Well, I've got to say it, because if I don't say it out loud, then she's certainly not bound by it. 5206 Grandview Drive is the address I'm ordering you not to return to. But you're ordered to have no contact with the victims. Do you understand that?
Who is the victims? I thought it was.
I can't understand you. You're mumbling.
Who is the victims? I thought it was a victim.
Well, looks like Henry Taylor yeah, Henry Leverett Taylor. Understand?
Yes. Yes, sir.
Okay. Now, you're also ordered to have no weapons on or about your person. If you own or have access to a weapon, you are ordered to surrender that weapon or those weapons to the Orange County Sheriff's Department within 24 hours your release from the Orange County Jail. You'll get a receipt. You're to file that with the clerk. You're to consume no alcohol and no drugs not prescribed for you by your own physician. Do you understand all those things?
Yes, sir.
All right. Now, anything else requested in this case by the state?
No, Your Honor.
All right. Counsel?
No, Your Honor.
Anything?
No, Your Honor.
All right. Ma'am, if you have any questions, you're going to want to address them to your attorney.
Okay.
Good luck. Okay, let's see. Next case number is, well, there are two case numbers. 2019 CF 14651BO and 2020 MM2160. All right, the name is Elijah Mohammed Caba.
Yes, sir.
All right. Well, sir, I have a failure to appear in Division 19. It says you failed to appear for a pretrial conference on March 10th of this year.
Yes,
that
sir.
court issued a capias and ordered you held no bond. And then you have new charges, a battery. It's charged a misdemeanor battery and a criminal mischief also.
Your Honor, can I say
It's
something
almost
real
like
quick?
they charged it as a felony. Anyway, all of that, the new charges are pursuant to an arrest warrant wherein probable cause was found. Now, I'm looking at your affidavit of insolvency. You do qualify for the public defender. Do you understand?
Yes, sir.
So I'm going to appoint the public defender to represent you in both cases. You're going to continue to be held no bond on the failure to appear pending further order of the court that issued the capias. As to the domestic charges, your bond on the domestic violence charge will be set at $500. The warrant sets your bond at $150 on the criminal mischief charge. You're going to be ordered to have no contact with the victim or victims in the domestic case. You're to maintain a separate residence from the victim or victims. You're to consume no alcohol, no drugs not prescribed for you by your own physician. You're to have no weapons on or about your person. Any weapons that you may own or have regular access to are to be surrendered to the Orange County Sheriff's Department within 24 hours of your release, and a receipt that you will be provided with will be filed with the clerk's office. Do you understand?
Yes, sir.
All right, now, Any questions that you may have at this point, you're going to want to address to your attorney. So,
I can't talk to my lawyer.
thank you, sir. Okay, next case number is 2020 MM9222. Probably AO, yes. And Kenneth Sebastian Humphrey. Is that you, sir?
Yes, sir.
All right, I'm going to ask you to speak up just a teeny bit. You're charged with battery. It's alleged to be a domestic battery. Do you understand that?
Yes, sir.
All right. I did review the affidavit. I do find probable cause for the charge. You also filled out an affidavit of insolvency, which indicates you qualify for the services of the public defender. So I'll appoint the public defender to represent you at this time.
All right.
All right. Now, good morning.
Morning.
What I'm going to do is I'm going to need y'all to speak up. You can't take off your masks, but those masks are killing me. I can't hear what people are saying. You cannot take it off.
Okay.
You just have to talk a little louder than you normally would. Excuse me. All right. Which of you is Summer?
I am.
Okay. Summer, you're the named victim here.
Mm-hmm.
And this guy over here is your brother, right?
Yes, sir.
Okay, so he's in jail. And what we're doing here this morning is called first appearances.
Mm-hmm.
And it's at this point that the court decides whether he represents an ongoing danger sufficient to just keep him in jail until further order of the court, or whether to give him conditions of release. Now, he does qualify for what's called pretrial release, which is a non-monetary form of release. But in order for him to get any non-monetary form of release, you as the victim have to be given an opportunity to be heard, and you can tell me what you think about that, or your thoughts about what you think the court ought to order. Okay?
I think he should be released. He's not a danger to society.
I'm going to need you to get closer to that microphone.
I think he should be released. He's not a danger to society. He's someone who lost their anger, and it spiraled into a stupid argument about I don't even know what anymore.
Something to do with your cat. That's
my
what
cat.
the affidavit said.
My cat was being really loud, and he was yelling at her, and I told him to please stop yelling at her, and it just...
Well, see, you'll get a chance later you're going to be talking to the state attorney. They're going to talk to you about whether you want to prosecute or not. And so you'll get a chance to tell them all of that. What I want to hear today from you, and I don't mean to be impolite to you, but we got a lot of stuff to do. We got to get it done. What I'd like to hear is what you think about him getting out of jail.
I think he should be let go.
Okay, so you want him out of jail.
Mm-hmm.
Now, another thing I have to deal with is whether I'm going to let him have contact with you. So you guys live in the same house?
Yes, sir.
So do you want him to come back there?
Yes, sir.
Okay. So if I ordered that he be released PTR, and I said that he is to have no hostile contact with you as a condition of his release, no arguing, no sibling rivalry, none of that stuff. He participates in that, he comes back to jail. So will that work for you?
Yes, sir.
Okay. Does he own any weapons?
No, sir.
Okay. And how about drugs or alcohol? Are they a problem?
No, sir.
Okay, so you'd like for me to do PTR, and he's to have no hostile contact with you, and allow him to come home?
Yes, sir.
Okay, anything else you can think of?
Mm-mm.
I didn't mean to cut you short, but
it's all right.
it's just the way we function, Okay, well, I can do that. Is there anything else you want to tell me?
No, sir. Thank you.
Okay, well, thank you for being here. Who do you have with you today?
This is my mom.
Mom? Mom to both of you.
Yeah, yes.
That puts you in a tough position, huh, Mom?
They're really great kids, yeah.
Well, I don't doubt for a second that they are. And sibling rivalry is as old as the Bible, I think. So,
Yes, sir, it is.
you know, in this case, they just have to figure out, you know, how to come to grips with the things that started the argument to begin with.
Yes, they do, but I think it's going to get a little better now.
Okay, well, hopefully it will. And, you know, if there's anything needed in terms of maybe some anger management, stuff like that, you can always make that request as the case evolves, okay?
Okay, thank you.
All right. Well, thanks for being here. All right. So I think PTR probably works. Now, what I want to stress to you, Mr. Humphrey, is pretrial release is a monitored kind of release. You may get out of here without, you know, having to post a bond, but that doesn't mean you're completely clear of all of this. I'm also going to order that you have no hostile contact with your sister as a condition of your release. So you will be allowed to go home. Any argument, any problems that arise that you are responsible for could bring you right back here to the jail. Understand?
I understand, sir.
Now, I've appointed the public defender for you. If you have any questions, you want to direct them to your lawyer. And you individually, how old are you?
21.
You're old enough to realize that sometimes you need a little outside assistance to figure out how to deal with issues like this.
Yes.
So are you a student anywhere?
No.
Okay, well, you may want to look into some sort of anger management course. They have one-day courses that you can attend that help give you the tools that you need to deal with anger and stop this stuff from happening in the future, okay?
I definitely understand, though. I do need some therapy.
Okay. So you're going to seek that on your own?
I can try my own, or my mom can help me.
Okay. All right. Well, it sounds like a plan. All right. Well, good luck. So it's just straight PTR. And most of that checking in is being done virtually nowadays, on the phone and stuff. Yeah, I'm good with
Yes.
that. All right. No hostile. Let's see, next case number is 2020 MM 9207AO, and that is Denise Johnson. Is that you, sir?
Yes, sir. The Q is silent.
Is that right?
It's Donique. The Q is silent.
Okay, Donique. Got it. All right, well, you're charged with battery. It's alleged to be an incident of domestic violence. I did review the charging affidavit. I do find probable cause for the charge. And your affidavit of insolvency indicates that you qualify for the services of the public defender. So I'm going to go ahead and appoint the PD for you at this time. You understand that?
Yes, sir.
All right. We don't have a victim, which in a way kind of ties my hands. It says here you do qualify for PTR, but without input from the victim, I'm not going to order PTR. What I'm going to do is I'm going to set your bond at $500. You're going to be ordered to have no contact with the victim. You're to maintain a separate residence from the victim. I'm going to order that you consume no alcohol, no drugs as a condition of your release unless the drugs are prescribed for you by your own physician. You're to have no weapons on or about your person. If you own any weapons or regularly have access to them, you're ordered to surrender them to the Orange County Sheriff's Department within 24 hours of your release from the Orange County Jail. This address, 6344 Raleigh Street, apartment 1112, is that where you live with the victim?
The victim doesn't live there, sir.
The victim does not live there?
No, sir.
Okay, state?
Your Honor, the alleged crime occurred at the victim's residence, and it is different from Mr. Johnson's residence.
All right, let me see if I got. I see, okay, so.
And the state would ask just for a straight maintain separate residence.
Oh, yeah. Maintain separate residence, do not return to 1224 South Hiawassee Road, apartment 631, as an additional condition of release.
Yes, sir, I understand.
All right, now, any questions?
No, sir.
All right, good luck.
Thank you.
You're welcome. You know, where was the point in time where they moved these domestic cases up to the first thing in the morning? Has that been going on for a
Only
while?
during the pandemic, Your Honor.
Just during the pandemic?
When we started having everything in one courtroom.
And I was going to ask you all that too. Anybody that can fill me in on that. Where was the point at which the decision was made to have only one courtroom functioning instead of two? And what was the purpose of that? Anybody know?
It was during the pandemic, Your Honor, when the circuit court needed access to the second courtroom. They do the virtual hearings in courtroom 2 with some live. I believe the inmates are taken into courtroom 2 for virtual circuit court hearings.
Is that still going on?
It's going on right now, yes, Your Honor.
So for things like felony arraignments and, you know, stuff where they didn't want to transport somebody?
Those are still being done in, I believe, courtroom 3. Courtroom 2 is being utilized for various motion hearings and plea hearings for inmates that.
Okay.
And the judges are remotely, I believe the judges are remotely presiding over those hearings.
Yeah, you know, the problem with it, from my perspective, is that nobody ever called me and asked me what I thought about any of this. I think they looked and they saw retired and just decided they didn't need to consult with me anymore. So, you know, this was all being done without my knowledge or input. Not that my input's ever been respected by anybody up the line.
Of course it has.
But I always like to, you know, throw a few words in here or there. Oh, well. So let's see. Next case number is 2020 MM9199AO, Maurice T. Johnson.
Yes,
Is
sir.
that you, sir?
Yes, sir.
All right, Mr. Johnson, the charge is battery. It's misdemeanor domestic battery. Case is assigned to Division 50. I did review the affidavit. I do find probable cause for the charge. Reviewed your affidavit of insolvency, and it's been determined that you do qualify for the public defender, so I'll appoint the office of the public defender to represent you. That being said, wonder why he doesn't qualify for PTO. What's the deal on that? Has he got an out-of-state address or something? Yep, Pittsburgh.
Yes.
Got it.
Yes, sir.
So your bond is going to be set at $1,000. You're going to be ordered to have no contact with the victim or victims as a condition of release. You're to maintain a separate residence from the victim or victims.
Of course.
You're to consume no alcohol, no drugs, not prescribed for you by your own physician. You're to have no weapons on or about your person, sir. Now, you understand I've appointed the public defender for you, sir?
Yes.
You need to answer out loud.
Yes.
All right, that's your attorney, so any questions or concerns you have, you want to address to your attorney.
Okay.
All right?
Yes, sir.
Okay. Good luck. Anybody ever watch Dr. Cole, the vet guy? Yeah. My wife watches it a lot. They deliver a lot of calves, don't they? How'd you like to have that job? No? Yeah, I think I'd pass on that too.
Yana.
Yes, sir.
All right. Would the court have any objection to setting bond at $100 cash? And I'm gonna explain to you why.
All right.
So Bond is at $1,000 right now. So it's gonna be $100 to get out if he uses the services of a bail bondsman.
Right.
My client said that he had about $300 to his name. However, since he is from Pittsburgh, he has no one in Florida that can actually sign for him. So he won't be able to use the services of a bail bondsman. So if you were to say his bond at $100 cash, he'll still pay that same $100 that he was gonna do with the bail bondsman to get out.
You know, it wasn't that long ago that the appellate courts said it was wrong to set a straight cash bond for somebody to get out, because historically it was used as a means to keep somebody in jail. You know, you could say back in the old days, $25, and $25 was beyond the person's reach, and they couldn't employ a bondsman, so the cash had to be posted. So, as far as you know, the appellate courts are okay with cash bonds?
No, I don't believe that they're okay with cash bonds. Matter of fact, I think they're trying to stay away from it.
Care to weigh in on that, State? Know anything about it?
Your Honor, I have no knowledge of what the appellate court's position is on cash bonds. I do know that there is a move afoot across the country to eliminate bondsmen altogether.
I don't think they want to hear. You just made yourself some enemies across the street.
Well, I just said there was a move afoot. Didn't say that I agreed with it, but but I do not know what the position in Circuit 9 is on as to cash bonds. So.
I don't think the circuit itself has ever addressed it. If they have, it would be another one of those times when they fail to call me.
Yes, Your Honor.
But I just know once upon a time, cash bonds were frowned upon by the appellate courts because of their historic use to keep somebody in jail. I personally don't have a problem with it. And if you're more comfortable with that for your client, you're right, $100 is $100, one way or the other. So I'll call it a $100 cash bond to get out, and then we'll take it from there.
Thank you very much, Your Honor.
Thank you. Not a problem. Good luck.
Thank you.
Sorry, Madam Clerk.
Thank you.
You may yell at him if you. This is after? This is the one we're doing now? Okay. Got it. Yeah, people do that all the time. It's the story of my life, sneaking up on me and stuff. Okay, next case number is 2020 MM9220. And the case is, let's see, Raphael Santiago?
Yes, sir.
All right. Let's see, Mr. Santiago, the charge is battery. It's alleged to be a domestic battery. I have reviewed the affidavit. I do find probable cause for the charge. And let's see, you do qualify for the public defender. So I'll go ahead and appoint the public defender for you. And you're out on bond on a petty theft charge from July of this year. So let's start with the charge itself. Having found probable cause and appointed the public defender, I notice you got some failures to appear on your record. Got a lot of felonies too, goodness. So I'm going to set your bond on the battery charge at $1,500. You're going to be ordered to have no contact with the victim. You're to maintain a separate residence from the victim. You're to consume no alcohol, no drugs, any weapons you own or have possession of on a regular basis. You're to surrender to the Orange County Sheriff's Department within 24 hours of your release. File the receipt you received with the clerk. And because I'm enhancing the bond on the underlying domestic charge, I'm going to take no action on the petty theft charge that he's out on bond on.
Thank you, Your Honor. Thank you. Thank you very much.
Try not to be so happy.
I appreciate it. Thank you.
All right. Somebody got to make the call, right? Let's see, next case number is 2020 MM9228AO. And the name is Brian Alexander Santos. Would that be you, sir?
Yes, sir. Oh, yes, sir.
Thank you.
My bad.
Your Honor, may the state hear the case number again?
Yeah, it's 2020 MM9228AO.
Your Honor, I'm showing 1043AW.
Yeah, they changed it.
Oh,
So somebody scribbled through that case number and wrote this case number in.
okay.
Simply designed to confuse you when we call the case.
So that was 922AO.
9228AO.
AO. Thank you.
You're welcome. Well, sir, you're charged with battery. It's alleged to be an incident of dating violence. It's a misdemeanor of the first degree. I did review the charging affidavit. I do find probable cause for the charge. And your affidavit of insolvency, well, based on the affidavit, it appears that you qualify for the public defender. So I'll go ahead and appoint the public defender to represent you. Understand all that?
Sir.
All right. All right, bond is going to be set at $500, sir. You're going to be ordered to have no contact with the victim or victims as a condition of release. You're to maintain a separate residence from the victim or victims. You're to consume no alcohol, no drugs not prescribed for you by your own physician. You are also ordered to have no weapons on or about your person as a condition of release. If you own any or have regular access to any, you're ordered to surrender them to the Orange County Sheriff's Department. Within 24 hours, you're released from the Orange County Jail.
Okay.
Now, you understand all that?
Yes, Your Honor.
You understand I appointed the public defender for you?
Pardon?
I appointed the public defender for you. So you have a lawyer.
I don't.
Now.
I do? Okay.
I can't hear you.
So he's my lawyer?
No, can't
I
hear.
work with the office, but
Okay. Okay.
So any questions you have, you want to direct them to your attorney, okay?
Okay.
All right. Good luck. Okay, next case number is it's quite a rap sheet there.
I'm going to traffic.
Yeah. 200534229. That's a out-of-county warrant, a writ of attachment on a child support issue.
Me?
Out of somewhere. Let's see. Where we at?
Grant Bundy, John.
Oh, he did? Oh. That's why he looks so confused. Grant Barker. Okay. All right. Next case number is 2020 CT 8122AO. And the name is Jason Green. Is that you, sir?
Yes, sir.
Okay. You're charged with driving while your license was suspended or revoked. It's charged as a misdemeanor. Currently has a $500 bond on it, and you do qualify for the public defender, so I'll appoint the PD to represent you. Also see that you're on federal probation.
Yes, sir.
So no way to resolve this thing today. So I'll leave your bond at $500. Is there a hold on him because he's on federal probation?
Yes, Your Honor.
Okay. So obviously you got a hold on you because of the probation?
Yeah.
So, but I've appointed PD for you, so if you have any questions, you want to direct them to the attorney, okay? Good luck. Okay, next case number is 2020 CT 1178AW. Name is Vince Anthony Robinson.
Yes, sir.
All right, sir, you are charged with driving while your license was, no, it's no valid driver's license. Yeah, NVDL. And looks like you qualify for the PD. I'll appoint them to represent you. Also says you qualify for pretrial release.
Yes, I talked to a lady about that.
I'll authorize your release, straight pretrial release. State, did you want to be heard?
Your Honor, the state would convey an offer if he wishes to resolve his.
Would you like to hear an offer to resolve the case today? You have an option. You can do pretrial release, which means you'll leave under supervised conditions, the jail. Or if you think you might like to resolve the case today, the state's going to extend an offer, and then you and your attorney can decide whether or not you want to accept that offer.
I'm thinking it's only maybe be a fine.
What?
If I can be pretty much guaranteed it's going to be a fine or no jail time.
I'm not understanding what you're saying.
She probably did a credit time for the offer.
Huh?
What did he say?
She'll probably do a credit time for the offer.
It
You'll
is.
get out today and you'll probably have to do court costs and that's it.
If that's the case, yes, sir, I'll take it.
And the state's offer is an adjudication of guilt, 2 days Orange County Jail, 2 days credit time served, don't drive without a valid driver's license, and court costs.
Okay, why an adjudication? What is?
He has a previous adjudication, not for a traffic offense, but he's been adjudicated on domestic violence battery, Your Honor,
Let's see, one misdemeanor, two.
in 2019.
Okay. Counselor, you care to be heard on that, the
Oh,
adjudication?
no, Your Honor. You can be out
Okay.
there, sir.
All right. Well, do you understand the offer, sir?
Only court costs. Yes, I understand that. Yes, I understand that.
Okay, do you want to accept the offer, or you want to go?
The only thing I have to do is pay court costs. Yes, I will accept that, sir.
Okay, raise your right hand. Do you swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, sir, the charge is no valid driver's license. The offer is an adjudication of guilt, credit for time served here at the jail, court costs, and an order that you not drive without a valid driver's license. Do you understand all that?
Yes, sir.
And you wish to accept that?
Yes, sir.
You understand what the adjudication versus a withhold means?
Can you explain that?
Well, it's real simple. An adjudication is a conviction. A withhold is not a conviction. So you're being convicted of driving without a valid driver's license today if you go with that offer.
Okay. All right, I mean, I figured it's probably gonna be a conviction anyway. So I'm gonna be guilty
Well,
anyway.
that's your call.
Yeah, I'm gonna
Nobody
be-
can predict what's going to happen.
I'm gonna be guilty anyway. It's nothing that I could do to
So you
make
want to go
that-
with the offer?
Yes,
or-
sir.
Okay. Well, then I'll accept your, well, you're going to enter a plea of no contest, right?
Okay.
All right. I'll accept your plea, adjudicate you guilty of the charge, sentence you to time served here at the Orange County Jail. Order that you pay court costs. Can you pay $25 a month toward court costs?
Yes. How much is it?
It's $200 and something dollars, I think.
Good Lord Almighty.
Oh, yeah, it's cheap.
Okay.
You got to pay for being convicted.
I
You
know.
know, it's
Wow.
not free.
Okay.
It's like everything else in life.
It is. It
really
is
not.
what it is. I didn't think it was gonna be that much, but okay.
So you still want to go with the offer?
Yeah.
All right. Can you afford $25 a month?
Oh, $25 a month?
To pay
Yes,
your
I can
court
work
costs.
that out. Yes,
Yes?
sir. I can work that out.
Okay. Well, then I'll order you to pay court costs I'll set it at $25 a month starting February the 5th and each month thereafter until paid in full.
That's fine. I get a little extra money, I'll go ahead and take care of all of it.
Right. No driving without a valid driver's license.
Okay, thank you, sir.
Okay? Good luck.
All right. Excuse me.
One of these.
Sir?
This is an arraignment, is it not?
No problem.
Thank you, sir.
No problem.
Thank you, man.
See how quick I pick up on this stuff? Well, you knew that already. You already knew that. Okay, next case number is, what is the case number here? It's on there somewhere. Oh, there it is. 2020 MM 583AA. And let's see, you are, is it Jesus or Jesus?
Same, Your Honor. It's Jesus in Spanish and Jesus in English.
Okay. Jesus Antonio Marquez Jr.?
That is correct, Your Honor.
All right. You're charged with petty theft with a prior theft conviction, so it's charged as a misdemeanor of the first degree. Today, you're here for an arraignment on that charge. You do have the public defender representing you in the case. You got 37 days time served. Your case is assigned to Division 84. So, would the state be making an offer on this case today?
Yes, Your Honor.
Would you like to hear an offer to resolve the case today?
Yes, Your Honor.
Okay.
And the state's offer is an adjudication of guilt, 45 days Orange County Jail, 37 days credit time served, no contact with the victim or witness, no return to the scene, which is the Family Dollar store at 5997 Edgewater Drive in Orlando. Abide by all trespass warnings and court costs. All of the merchandise was recovered.
All right. And, no return. Okay. Did you understand that offer?
Yes, Your Honor, I did.
All right. It would be an adjudication, a conviction, which means, because you have a prior on your record, that if you get charged with petty theft again, it would probably be filed as a felony. You can't get number 3 until you get number 2, and this would be at least number 2.
That's correct.
Understand?
Yes, Your Honor.
Okay. And so how do you wish to plead to the charge?
No contest, Your Honor.
All right. Now, anything you want to tell me about yourself or the case?
No, Your Honor. No, Your Honor. No.
Okay. Then I'll accept your plea of no contest, adjudicate you guilty of the charge, sentence you to 45 days Orange County Jail with credit for 37 days time served. Order that you are to have no contact with any witnesses in the case as a condition of your release, that you're not to return to the dollar store where the alleged theft occurred, that you are to abide by any trespass warnings that you currently have or that are issued to you as a condition of release. There was one more thing, State. What was the last thing you said?
That was it, court costs, Your Honor.
Oh, yeah, and you're ordered to pay court costs.
Your Honor, we also need to advise on that this is going to be his second conviction. So the next one is going to be a felony. You understand that?
Yep.
Actually,
Okay.
Mr. Thompson, this...
Court costs, I'm going to impose court costs. Can you pay $5 a month toward the court costs?
Yes, Your Honor. I could pay $10 a month or $20 a month. I currently have a full-time job now.
Okay.
I did
so
get in
you wanna
contact
make
with.
it-
I did get
How
in
much
contact.
do you want to pay them?
I could pay $25 a month, sir.
Okay, let's do $25 a month. I'm going to make your first payment due on March the 1st of next year to give you time to get your life back together after you get out of jail. And it'll be $25 a month on the first of each month, starting March 1st and each month thereafter until paid in full.
Yes, Your Honor.
All right, any questions?
No, Your Honor.
Good luck.
Thank you. Happy New Year.
You're welcome. You too. Okay, next one I've got is case number 2020 MM9221, Division 61, Irving August.
He's mental health, Your Honor.
Mental health.
Your Honor, defense will enter a plea of not guilty.
Okay, so you're going to waive his appearance at first appearance?
Yes, Your Honor.
All right. I'll appoint the office of the public defender, indicate his appearance is waived by his attorney. What do we got? Petty theft with a prior, trespass simple, and bonds are, finding probable cause. Set his bond at $500 on count 1, $100 on count 2. Order that he not return to the Walmart at 3101 West Princeton Street as a condition of release. Have no contact with any witnesses involved in the case. And I think that'll do it. Good luck. Well, he's not here, so spiritually, I wish him good luck. Let's see. Case number here is 2020 MM9219. Lisa Marie Lewis. That's you?
Yes, sir.
Parents Elvis fans?
Yes.
You've probably heard that a few times, right?
Yes, sir.
Trying to think. Lisa Marie Preston. Something about her that comes to mind. Oh, well. The case is in Division 84. The charge is petty theft. It's charged as a misdemeanor of the second degree. You do qualify for the public defender based on your affidavit, so I'll go ahead and appoint the PD for you. And then I see you're out on bond on a possession of cocaine charge. Looks like you got ROR'd back in October, and a trespass in a conveyance. So, as to the petty theft charge, do you understand what you're charged with?
Yes, sir.
And you understand I've appointed the public defender?
Yes, sir.
Okay. Now, State, is this a case that you'll be making an offer on?
Your Honor, if I may have just, I'm trying to ascertain whether or not the merchandise was recovered. If I may have just one moment. Yes, Your Honor, the state is willing to make an offer. It would be an adjudication of guilt, 5 days Orange County Jail, 2 days credit time served, no return to the Walmart at 8101 South John Young Parkway, no contact with witnesses, restitution in the amount of $76.81. Abide by all trespass warnings and court costs.
Would you like to accept this offer and enter a plea of no contest now?
All right. So, Ms. Lewis, raise your right hand for me. Do you swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you're entering a plea of no contest to a petty theft charge. Is that correct?
Yes, sir.
And you understand what the offer is from the state?
Yes, sir.
Had a chance to chat with your attorney for a moment?
Yes, sir.
Do you believe it's in your best interest to enter a plea of no contest today?
Yes, sir.
Okay, any questions?
No, sir.
All right. Well, anything you want to tell me about yourself or the case?
No, Your Honor.
All right. And I'll accept your plea of no contest, adjudicate you guilty of the charge, sentence you to 5 days Orange County Jail. You have credit for 2. Order that you not return to the Walmart at 8101 South John Young Parkway. You're to have no contact with any witnesses involved in the case. You're to pay restitution in the amount of $76.81. You're also going to be ordered to pay court costs. You're to abide by any trespass warnings that have issued or that are issued to you in the future. Now, as to the cost and the restitution, how much you think you can afford to pay a month? And be realistic, don't oversell yourself.
Honestly, I'm homeless, so like $5.
5? Okay, if we start the $5 at, say, February the 10th, you think you can get it together by then?
If I'm not in jail, yes, sir.
I didn't hear
If
you.
I'm not in jail, yes, sir. Because I'm still out on bond.
Okay, well, you're not going to be in jail as a result of what I'm doing today, so...
But what?
Well, you're going to be here for a couple of days. Why don't we make it March 1st?
Okay.
Okay? So, I'm ordering you to pay the restitution and court costs at the rate of $5 a month starting March the 1st. Same day every month until that's paid in full, okay?
Okay.
All right, any questions?
No, sir.
Good luck.
Thank you.
You're welcome.
And you would-
You took no action on out on bond, am I correct?
Oh, yeah, she is out on bond on something. Because she resolved this case today, I'm not going to take any action on the case she's out on bond on. Okay, next case number is, gotta be a case number in there somewhere. 2020 MM9223AO, that's Division 82. Charges possession of drug paraphernalia. Your name is Christina Rose Torres?
Yes.
All right, Ms. Torres. You understand the charge, possession of drug paraphernalia?
Yeah.
All right. You did fill out an affidavit. The affidavit does indicate that you qualify for the public defender. I'll go ahead and appoint the public defender for you in this case. Do note that you're out on bond on a prostitution and lewdness as a third or subsequent violation. That goes back to August of this year. So as to the possession of paraphernalia, State, any offers you want to extend on that?
Yes, Your Honor. The offer is an adjudication of guilt, 5 days Orange County Jail, 2 days credit time served, and court costs.
Okay.
You probably got that.
Okay.
You want to accept that?
Yeah.
Okay. So plea will be no contest, counsel?
Yes, yes, Your Honor.
All right. So you understand that by entering the plea, you waive your right to have a trial in the case?
Yes.
And you also waive your right to require the state to prove the charge against you beyond a reasonable doubt?
Yes.
All right. All right. So I'll accept your plea of no contest, adjudicate you guilty of the charge, sentence you to 5 days Orange County Jail. You have credit for 2.
Okay.
Going to be ordered to pay court costs. Let's talk about a payment on that. How much you think you can afford a month?
I would say $10.
$10? How about we start those payments on March the 1st?
That's fine.
So $10 a month toward the court costs, starting March 1st until paid in full. No action on the cases she's out on bond on.
Thank you.
You're welcome.
Okay.
Good luck.
Morning, Your Honor.
Fidgety. Drugs, you think? Withdrawal? Seen it many times. Many, many times. Okay, next case number is 2020 MO1368AO. Oh, yes, and the name is Isaac Roman Flores.
Yes, Your Honor.
That you, sir? All right, well, sir, you're charged with urinating or defecating in public, which, not really a misdemeanor of the first degree. It's a city ordinance, 43.6. I do find probable cause for the charge. According to your affidavit, you do qualify for the public defender. Now, you got a bond of $500, and so you have the option of posting the bond and getting out of jail. Or if you would like, I can see if the state wants to extend an offer to you to resolve the case today.
Yeah, that'd be the best. The best.
You wanna do that?
Yes, yes, Your Honor.
Okay.
The offer would be an adjudication of guilt, 2 days Orange County Jail, 2 days credit time served, and court costs.
So the adjudication, I'm looking at his record. He got a theft that goes back to 2010 in
out-of-state
Georgia.
adjudications, convictions.
That's about it.
I can't give him the withhold. Your Honor, he has out-of-state convictions, and that is why the state is going with the adjudication.
All right. Okay. So he's gonna have to carry around a conviction for the rest of his life for peeing in a parking lot. Oh, my goodness. Oh, well, that's
And
life, right?
Your Honor, the adjudication or the withhold of adjudication is 100% the court's purview, Your Honor.
Well, I understand that, but I also believe that at this stage of the process, if it's an arraignment, I feel comfortable, monkeying around with the offers you make. But at a first appearance, first of all, I don't believe that you're obligated to extend an offer. And if you're kind enough to extend the offer to allow the person to resolve the case today, then my thinking is that the least I can do is respect the offers that you extend. And by the way, I've generally felt like the offers that you extend are reasonable and within reach for people. They're not as harsh. We had some people sitting in your spot not that long ago who on this case would want a minimum of 60 days. And if it's charged as an M1, they had no problem with standing up and asking for 6 months on this kind of case. Fortunately, they're all gone now. So,
Your Honor.
Counsel, did you want to be heard?
Yes, the state cannot issue a withhold because of convictions out of state. However, I do believe if my client pled to the bench, you could offer a withhold in this case.
Right.
And credit time served and court costs.
Yeah, I don't disagree with that. I think you're absolutely correct.
And in this scenario, since he does want to resolve the case today, it'll be a straight up plea to the bench.
Yeah. The problem with withholds a lot of times, and I realize, your job is to get the best you can get for this person under these circumstances. But the problem is, oftentimes the people who defense attorneys spend a lot of time and effort arguing about whether it's a withhold or an adjudication already have them on their record. And so it's 6 of one, half dozen the other. And I understand, how all that plays out. But you're absolutely correct about my discretion. It's just a personal thing with me. So thank you very much.
All right.
All right, sir. So you're entering a plea of no contest. Is that correct? Or not?
I'm not sure.
All that talking to me.
Yes, I understand. I just don't know the adjudication. I don't.
All right, so, and Your Honor, am I correct in saying that the bench will be offering a withhold?
No, I didn't say that.
Oh, if we were to plead to the bench, what do you think? Would you have an offer?
Your Honor.
I don't have a separate offer from the state because I have no problem with the offer the state made.
Okay.
So it'll be an adjudication.
Look, if you want to keep the case out today,
What do you think of this mask? I have no idea where it came from. I don't know which is up and which is down on this thing. Do you think the stars are up? Look good that way?
I just want to.
All right, Your Honor, we'll expect the state offer and enter a plea of no contest.
All right. So, raise your right hand, sir. You swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. So you entered a plea of no contest to the charge of urinating in public,
Yes, Your Honor.
and you believe it's in your best interest to do that today?
Yes, Your Honor.
All right. Any questions?
No, Your Honor.
Any comments you want to make before I finish it?
No, sir.
All right. I'll accept your plea of no contest, adjudicate you guilty of the charge, give you credit for the time you've served here. In other words, you're going to get out of jail today. Order that you pay court costs. And how much you think you can afford a month for the court costs?
I'll just pay it.
Just pay it in cash?
I'm sorry?
You're just going to pay it?
Yes, Your Honor.
All right.
I just want to get this.
Here's what I'll do. I'll give you 60 days to pay the court costs in full.
That's
All
fine,
right?
Your Honor. Yes.
Good luck.
Thank you.
You're welcome. Two. Dos. You speak Spanish? Dos. Ah, you don't, do you? Okay. Here are the out-of-county ones. So, let's see. What's the case number here? 2020 CT 265. The county is Flagler. And your name is David Thomas Cook?
Yes, sir.
All right, Mr. Cook, you're being held on an out-of-county warrant. It's on operating a motor vehicle while your license was suspended.
Yes, sir.
And the bond amount is $500.
I do have a license now. I mean.
Well, but that's something you got to resolve with Flagler County.
Yeah.
So you can post a bond here of $500 and get out of jail. Or you can wait until Flagler County comes and gets you.
Right.
Understand?
Yes, sir.
Now, here, because he's got a monetary bond, A, I'm not appointing the public defender because he can bond. And then B, if Flagler doesn't come and get him, it used to be, that would be 72 hours. If they haven't picked him up by 72 hours, the court would be notified so we could bring him back and figure out whether or not we're going to...
Your Honor, during the pandemic, that is not the case. During the pandemic, we do not know when the counties will be picking them up. And pursuant to the Supreme Court order, those timetables are no longer in effect right now during the pandemic. So we cannot advise them that they would be picked up within 72 hours. During the pandemic, it's just whether or not that jurisdiction is transporting.
In his case, that would be because he can post a bond and get out.
In his case, it would be that we couldn't tell him when they would pick him up.
Right.
Because of the pandemic.
So what happens if he doesn't get picked up?
And then our circuit would reach out to that circuit, and I believe that's Flagler.
Right.
And see whether or not it can be resolved or taken care of here. Also, the state has a question. I see 2 additional case numbers for out-of-county warrant.
Well, there's that one. Let's see. Huh? There's another one.
He has 3, and they all have bonds.
CT 265, also with a bond. Out-of-county warrant, same charge. I only see, I think, 2. Let's see.
I'm seeing
265.
2020 217452, 2020
Actually, I only have 1.
2521, and then the CT 265.
He was already I-8 on those back in November.
All right, thank you.
So those, not a factor.
No, those are not a factor. Your
Okay.
Honor.
So, well, because of COVID, I can't really tell you that something's going to happen within 72 hours if you don't bond. The
Right.
key in your case is you can bond to get out of jail. Understand?
Yes, sir.
No.
And Your Honor, because it's Flagler County, and we have not heard whether or not they're transporting, in an abundance of caution, the state would recommend that the local public defender's office is appointed in case he cannot bond.
Well, I'm never sorry about appointing a public defender, so does that work for you, Mr. Public Defender?
Yes, Your Honor, and what we do in our office, we're also in contact with the state attorneys in these counties, and we're getting in contact with them to see if we could plea them out on those out-of-county cases here. So,
Well, his affidavit
Do all
indicates
the
he
cases?
qualifies.
You do
So
all
I'll
the cases
appoint
here?
PD for you.
I would like to try to resolve something, because I've been here 57 days, so.
Well, you can't resolve anything here on a Flagler County case, you understand?
Okay.
Well, we can't do it at IAs, but we can do it here, Your Honor.
It's Mr. Thompson, it depends on what type of cases. they're-
Depending on what type of.
So, there's a possibility.
Does corrections still keep track of these? So that if somebody's here under these circumstances and they don't bond out, how long will you let them sit before you notify us
I'm aware of that.
that they're still here and they haven't been picked up by Flagler? Do you still go by the 2472 thing?
Sometimes the judges
Terrific.
say, no.
That's the
change the bond, we don't
saving
wanna
grace
resolve
of all of that. The fact that y'all are still doing that. Yeah. So I ought to give credit where credit is due.
And, but the offers have to be done by those ASAs. Yep. You first give.
So I'll appoint the PD for you,
Okay.
all right?
Yes, sir.
Good luck, sir. Are these people messing with me? Are they messing with me? Taking advantage of my lack of knowledge?
Yeah, can you find that out for me? Because I'm still.
No PD? You don't want them? No, I'll appoint PD. Yeah, sure. PD wants to be appointed. Far be it from me to argue.
Okay.
That's why I became a judge. Quit being a lawyer so I wouldn't have to
It's not
argue
the same pen I have here in jail?
anymore.
I don't know.
All right, sir. I'm gonna have to start charging you rent if you don't get out that door. Well, let's see. Next up is gonna be case number 19 CT 3791, Osceola County. And the name is Faith Marie Emmons.
Yes, sir.
Okay, got a warrant out of Osceola for failure to appear on a driving while license suspended or revoked. And the bond on that is $1,000. And then, let's see, 3791. So, is Osceola still transporting?
Yes, Your Honor.
Okay, good. So you understand that? It's on a failure to appear?
I didn't know.
Okay,
until.
but I need yes,
okay.
no, okay?
Yeah, okay,
You
yes.
understand why you're being held?
Yes.
It's a
Sir.
failure to appear in Osceola County on a driving while license suspended, and you have a bond of $1,000, which means you can bond here, or you can wait for them to come and get you and go down there and resolve it.
Okay.
Understand?
Yes, sir.
Any questions?
If I paid for all and my license is currently
You pay
active.
for what?
For all the tickets, and my license is currently active. Does that mean anything towards it?
In Osceola, it might.
Okay.
You know, we don't resolve their cases. It's one county doesn't resolve another county's cases.
So if I get bonded out here, I don't have to go to Osceola until
Yeah,
court?
if you bond out here, you're gonna get a court date to appear in Osceola,
Okay.
and you need to write it real big on your calendar so you make sure you show up.
Okay.
Good luck.
Thank you.
No PD. Okay, next case number is 19 CFO 262. And this is Walton County. An out-of-county warrant on a felony violation of probation. Let's see, your name is Tracy Ann Perdon?
Yes.
All right. Let's see, warrant is valid, felony violation of probation, no bond, placehold, we will pick up. That would be out of Walton County.
Okay.
Walton County is what?
In the
Panama City?
It's in the Panhandle. It's 5 hours away from here.
So,
I didn't even
because
know.
you're being held no bond,
I didn't even know I
I
had
think
a
it would be
warrant.
appropriate to appoint the public defender locally. So I'm going to appoint the public defender for you locally.
And that's going to be your best friend for a while. So, you understand?
I guess. What am I supposed to do about my kids?
I can't hear you.
I said, what am I supposed to do about my kids?
What is she supposed to do with her kids? How do you answer that? Don't violate your probation?
That's probably not the right answer.
I don't know. I have that question about my own though. What do I do with the kids? Well, I can understand. That would create a problem, wouldn't it? Just suddenly you got locked up. And what would you do with your kids? I might tell my kids to find a safe bridge to go live under until I get out of jail. And they probably would. Let's see, next case number is 202000, Star Trek time period, 3257 Manatee County. The name is Reginald Lee Shorter. Is that you, sir?
Yes, sir.
You got a warrant for a felony petty theft out of Manatee County with a bond of $1,500. Do you understand that?
Yes, sir.
Any questions about it?
No, sir.
You understand that you can post a bond here, but that doesn't resolve the case. You still have to go back to Manatee County and resolve it.
Yeah, I'm having trouble with the posting bond here because none of the bondsmen wants to, because it's out of county.
Well, I'll appoint the public defender for you locally, and but I'm not at liberty to change the bond amount.
Okay.
All right? Good luck. Here, I didn't give you that one. Good luck. Okay, next one is Volusia County. 2018105967. And the name is Amanda Teague.
She bonded, Your Honor.
Bonded, okay. And last but not least, Osceola, 20 CT 2302. And the name is Doya Sierra Wilson.
Yes, sir.
Would that be you?
Yes, sir.
Okay. You're being held on a warrant out of Osceola County. It says you failed to appear for an arraignment on a no valid driver's license charge. The court there set your bond at $2,000, indicated they would come and pick you up. So do you understand all that?
Yes.
All right, and then I see you're out on bond on a failure to appear on a leaving the scene of an accident without giving information. I'm not going to take any action on that. Your bond on the failure to appear is $2,000 in Osceola. You understand?
Yes, sir.
Okay. Any questions?
No, sir.
All right. Well, I mean, I could. Not sure why. But yeah, I'll go ahead and appoint the PD for her. And, assuming there's no objection from your office. Yes, sir? Ooh, people touch that. What am I supposed to do? Quick, give him my match. You're welcome. Well, it's almost 11:30. How do y'all feel about coming back at 1 o'clock?
That's fine.
Work for y'all?
Yeah.
Okay. So, I realize it's New Year's Eve. I'm not sure what it means. So, 1 o'clock it'll be. Next time she's here, she's going to try to come out here and see you. Okay, well, shall we crank it up?
We should. Did you see any issues? No. I'm on the last one that has out on bond, so.
Okay, let's see. Records on, and gosh, how many case numbers we got in this one? Several. Here's 2020 CF 11464, and then there's not a county one that's 20. Well, I don't know if it's 20. 0065036. That's out of county, out of Polk County. Okay. The name is Scott Keenan Bell.
Yes, sir.
Is that you, sir?
Yes, sir.
All right. Well, let's see. Mr. Bell, I have some new charges. This is pursuant to an arrest warrant.
Yes, sir.
That was signed, charging you with burglary to an unoccupied structure, grand theft third degree, and criminal mischief. Now, those cases are in Division 14, which may or may not mean anything to you. I did read the affidavit. I do find probable cause. Well, it was found originally by the judge who signed the warrant, but in an abundance of caution, I reviewed it and agreed that there was probable cause for the charges. You do, it appears, qualify for the services of the public defender, so I'm going to appoint the public defender to represent you.
Yes, sir.
And having found probable cause, I'll stay your bonds at $3,500 as to count 1, $150 each as to counts 2 and 3.
Can you tell me how much is that 10%, sir, please?
You are not to return to the church. I didn't see the name of it. Oh, New Hope Ministries Church, located at 1416 30th Street, Orlando, Florida, as a condition of your release. And then you have a out-of-county warrant out of Polk County. It's on a failure to appear on a petty theft.
Yeah, that was supposed to be handled. I did 75 days for that.
Well,
yeah, I'm sorry. I was like, the new one I understand, but the Polk County, that was supposed to have been handled the last time I was here.
Well, it gets worse, because Polk County wants you held on no bond.
On no bond?
No bond, that's right.
Wow.
So you have the bonds that theoretically you could post on the new charges.
Yes, sir.
You got no bond on that one. I've appointed the public defender for you, and that'll be as to both the new charges and the out-of-county warrant.
Oh, no
So,
bond on that? Wow. It's only a bicycle in Polk County, bro. Yes, sir.
Do they? The out of county one?
Can you tell me how much is the 10% of the?
Oh, the new
bond I
charge.
have out here?
So,
Damn, man.
all right, so yeah, there are other conditions as far as the new charges. No return to that location,
Oh,
which
yeah,
which I've
yeah,
already
yeah,
ordered.
yeah.
You'd have no contact with the victims or witnesses involved in that case. And what was the other one?
Polk County don't want me to have no bond. I got a job.
Goodness, that sounds like a domestic thing. You are not to possess any weapons as a condition of your release. You're to consume no alcohol, no drugs not prescribed for you by your own physician, also as a condition of release. So those conditions are as to the new charges here, not as to the out-of-county warrant out of Polk County. Understand?
Yes, sir.
And Your Honor, did you state a bond at 3,500?
Huh?
Did you state a bond at 3,500?
Yes.
Is there anything I could do about that? Like, that Polk County is supposed to be handled. The fact I don't have a bond, I have a job and everything I have to get to.
It's gonna be 350 for that one, and $100 each on both of those charges. But there's no bond on the out account, so you gotta wait until we get in contact with you, so we can back on track.
Do you know how long that's going to be?
And Your Honor, before we move to the next case, may the state go on the record. Edith Bush for the Office of the State Attorney for this session.
Jace Thompson on behalf of the Office of the Public Defender.
Oh, yeah. Forgot to do that. Well, let's see.
okay.
Next case is, let's see. Case number is 2020 CF 15323. And the name is Randolph Chamberlain.
Bonded, Your Honor.
Bonded. Got it. Thank you, sir. And then following that is 2020 MM 579880. Yeah, that's the one that gave me a little heartburn there. Oh, and then there's 2020 CF 10566. Are you Justin Matthew Goodman?
Yes, sir.
Okay, Mr. Goodman, you have some failures to appear in the in a felony case here in Division 10. That was on a possession of meth, soliciting funds from an unauthorized roadway, possession of drug paraphernalia. Says you failed to appear for a status hearing on 12/16 of 2020. The court issued a capias, set your bond at $2,000 as to count 1, $100 as to count 2, and $2,000 as to count 3. And then you have a violation of pretrial release. That case is in Division 80 on a misdemeanor. The violation alleged is that you were ordered to report to Orange County pretrial release on December 9th, 2020, for which you failed to appear, resulting in the issuance of a warrant signed by Judge Elizabeth Gibson, who ordered that you be held no bond on that one. And looking at the affidavit of insolvency that you filled out, it appears that you qualify for the public defender.
Yes, Your Honor. I will be requesting public defender.
I didn't hear you.
I would like a public defender.
You would like the public defender?
Yes.
Okay. I'll appoint public defender for you.
All right.
So, and that appears to be the end of our business today.
All right.
Thank you, sir. Yeah.
I'm sorry.
It's tantamount to absconding when you fail to report as your order. So,
Ma'am,
I guess that's not unusual.
okay.
All right, next case is 2020 CF 15327, Division 14. Charges are possession of methyl methamp, or also known as MDA/ecstasy, and resisting officer without violence. You do qualify for the public defender, sir, so I'll appoint the public defender for you.
Yes, sir.
The bond amounts per the schedule are $1,000 as to count one, $100 as to count two. So what I've done is I've appointed the public defender for you.
Yes, sir.
So if you have any questions, you may want to ask your attorney rather than me.
Okay,
Him you can trust, me you can't trust.
And Your Honor, can we get a no alcohol or drugs without a valid prescription order
Sure.
as well?
We can put that in there. That probably is a study in futility, but
Yes, Your
we'll
Honor.
put it in there anyway. No drugs and alcohol. It is New Year's Eve. So maybe I'll order that for the whole court.
all right, can I speak, sir, Mr. Burrow? Judge, Your Honor, yesterday, sir, when I was arrested,
Yes.
this particular incident, sir, I'm in a Salvation Army, the coalition program.
Right.
And I was walking, because like our building is like right there.
Well, wait a minute.
Yes,
I
sir.
mean, you're starting to give me the facts of the case.
Oh, no, I wasn't. I just was.
Yeah, what you were doing, where you were at, all of that is part of the facts of your case.
Yes, sir.
And it's incredibly dangerous for
I
you
know.
to do that. I mean, I'm looking at your record, and you
I
clearly understand how the
Yes, I
system
do,
works.
sir.
So if you say something today
I know, sir. I know what's going on.
that could be used against you,
Incriminated
I
against
guarantee
me.
you the state's going to take down notes, and it will come back to haunt you.
I understand.
Because you have the absolute right to remain silent, not give the state evidence to use against you, and if you choose to do so, you do so on a voluntary basis. I know your attorneys warned you, now I'm going to warn you.
Yes, sir.
Not the smartest thing you ever did.
Okay. Your Honor, I was just trying to just give you like something that was happening to me towards like, I just been going through a lot, sir. And I was walking, I got caught up in a situation that I got hurt and slammed. I'm already under medical care, and I'm in a program, and I have no money, Your Honor. I'm homeless. I've been homeless a year.
Right.
And I'm in the coalition, and I just actually had the opportunity to get housing, and I come to jail. And I have no money to bond out, sir, and my bond is nothing but $100. And I was just trying to ask you if you could release me to the coalition, like back to the program on R&R. I'll make sure I do not miss no court dates. I will make sure I'll do everything I got to do to comply with this case. But this case was just thrown on me this time.
Well, here's
And I'm
here's
trying to
the
get
issue.
R&R because I'm really homeless with no money, and they have all my stuff there.
I understand. Not the first time I've heard that.
Your Honor, before you make your ruling, I would like to point out, even though that he has an extensive history, I don't see any failures to appear.
I agree. I saw that there. But the problem is this. What you're asking me to do is to basically release you to the custody of the coalition.
Or just R&R or
They
PTR.
will not take custody of you.
I live there.
I understand you live there, but they're not going to be responsible for you.
I'll be responsible for it, Your Honor.
Well, and I'd
I'm
like
44
to think
years
that,
old.
And that may be a possibility, but it's not going to be a possibility today. This is first appearance.
I understand,
There's
but
a limited amount of stuff we can do at first appearance.
Yes, sir.
And, you know, as much as I would love to trust everybody that walks through that door, it just isn't going to happen today. So,
Judge Brewer,
thank you, sir. Good luck.
Can I ask you what?
It's an injunction order.
It's an interesting one. A bunch of case numbers here. Good afternoon. Your name, sir?
Jermaine Hess.
All right. Well, let's see. What do we got? Case number 2020 CF 15328. Charge is possession of cocaine. Bond is currently set at $1,000. And then 2020 CF 15349. Driving while license suspended as habitual offender with a bond currently set at $500. And let's see, you're out on bond on a trafficking in, well, I couldn't say that if I practiced. Phil, how do you pronounce that, State?
Benethylamines?
Trafficking?
That's just phonetically.
Yeah, well, good job. Better than I could do. But you got an attorney in that case, Robert Williamson, Division 12. Currently have a $5,000 bond. Then you got a driving while license suspended. Also an attorney there, Stephen Houston, with a bond of $500. So, here's what I'm going to do. I'm going to leave those bonds undisturbed. I'm not going to revoke them. Not going to deal with those. But I am going to enhance your bond on the cocaine charge to $2,500. I'll leave the bond at $500 on the driving while license suspended. And in the event that I didn't say it, you do qualify for the public defender, so I'll appoint the public defender to represent you in those cases. Right? Thank you, sir. Okay, next up. Tanifa Denise Kendrick?
Bonded, Your Honor.
Oh, bonded. Yeah, she could have PTR. How about Jamie Colleen Kimmel?
That would be me, sir.
All right, Ms. Kimmel, you are in case number 2020 CF 15329, charged with possession of cocaine and possession of drug paraphernalia.
Okay, yes, sir.
And then you're out on bond on a possession of methamphetamine and possession of drug paraphernalia charge from December 2nd of this year.
Yes, sir.
So, according to your affidavit of insolvency, you do qualify for the public defender.
Okay.
So I'll appoint the public defender to represent you on the
Okay.
new charges. Looks like, well, for attorney on the case that you're out on bond, it says unknown.
What's
Do you have
that
an
mean?
attorney in that case? No? Okay. Why don't I appoint the public defender for you on that one as well?
Okay.
That case number is 2020 CF 14327AO, counsel. So, okay, your bond on the new cocaine charge is $1,000.
Okay.
Really should be $100 on the drug paraphernalia, so I'll set it at $100.
Okay.
I am going to revoke your bonds on the earlier case where your total bond amount is $1,500.
What does that mean?
We'll set the bond on the possession of methamphetamine. The new bond is going to be $2,500 and $1,000 on the paraphernalia charge.
Okay.
And you understand that you're represented by the public defender, correct?
I think so, yes, sir.
All right, any questions? Good luck. Let's see, your name?
Louis Molina.
All right. Well, let's see, Mr. Molina, in 2020 CF 15344AO, you're charged with unlawful use of a two-way communications device to facilitate a felony and possession of meth with intent to sell or manufacture or deliver. Do you understand those charges?
Yeah.
Yes?
Yes,
Nope.
sir. Yes, sir.
Okay. And then you've got a, looks like a paraphernalia charge associated with it, which is a misdemeanor charge. That's 2020 MF 316AE. So let's start with the easy one. That'll be, you qualify for the public defender, so I'll appoint the public defender to represent you on all three of the charges. As to the paraphernalia charge, the bond on that I'll set at $100. As to the unlawful use of a two-way communications device, $150, and the possession with intent, the bond is $15,000. Although I'll lower the bond on the possession with intent to $5,000. And as I indicated, I've appointed the public defender for you. Do you understand, sir?
Yes, sir.
Okay. Any questions?
No, sir. No, sir.
Thank you. Good luck. Let's see, your name, sir?
Blake Nevilles. How you doing?
Nevilles, Mr. Nevilles. Well, let's see, what do we got here? In 2020 CF 15335, you're charged with driving while your license was revoked or suspended as a habitual offender. The bond is currently set at $2,500, and it looks like you qualify for the public defender, so I'll go ahead and appoint the public defender for you on that.
May I speak?
You're out on bond from 12/19 on a resisting without violence charge, 2 resisting without violence charges, tampering with physical evidence, and possession of a misdemeanor amount of cannabis. We got $500, ROR, $100. Okay. Your bond on the new driving while license suspended, and in the event that I didn't say it, you do qualify for the public defender.
Yes, sir.
So I'm appointing the public defender to represent you. I'll leave that bond at $2,500 on the new driving while license suspended.
May I speak?
As
sir?
to the, what do you got? On the 2 resisting charges, you got a bond of $100 on 15335A. Oh, I don't know what that letter is in the middle. What is that letter in the middle? A something O? It's just an extra mark? Okay. I'm going to increase your bond on that resisting charge from $100 to $1,000, revoke the current bond. As to the ROR you got on the other resisting charge, I'll leave that as is. And then your $500 bond on the tampering with physical evidence and possession of cannabis. The bond now will be $1,000 on the tampering charge and $500 on the cannabis. I'll revoke the existing bond.
Sir, may I say something, please, sir?
You want to talk to your attorney there, sir? Let's see. 8988? What number is that?
Yeah, that's the one, those cases we got on bond. That's
Oh, I see, yeah, 8988,
So
no action.
Okay.
And then it's 8987 is the one where I increased it to 1,000, I think.
Yes, Your Honor.
And then,
The felony is the 1,508.
right. That was a big loud boom back there. What do you think that was? Hmm? Oh, he kicked something? Could be somebody fell down. People do fall down, you know.
Thompson, what was the bond? What was the new bond on the out on bond on 14971?
What part of that?
That's the felony out on bond. Okay, never mind, I see it.
Yes, I will. Because I'm forgetting to do that. Aren't I? Aren't I? It's one action too many for me to deal with. I'm not a multitasker, you know. Good afternoon, sir. Your name?
Michael Patterson.
Michael Scott Patterson. Ah, yes. Okay, in 2020 CF 15324AO, Division 19, you're charged with grand theft, third degree of a motor vehicle, and possession of heroin. And in looking at your affidavit of insolvency, you do qualify for the public defender. Bonds are $1,000 on the grand theft charge, $150 on the possession of heroin. And I did review the affidavit. I do find probable cause for those. I see that you're out on bond on a possession of oxycodone and possession of drug paraphernalia charge. But as far as bond is concerned, you have an attorney in that one, Michael McGinn. The bond amount says NA. Does that mean he got ROR'd or PTR'd?
No,
or
he's
33
out on
days?
pretrial diversion, Your Honor.
Pretrial diversion.
Yes.
Well, you know, I think I'll take no action on it because diversion's going to revoke you anyway. So we'll let the judge the case is assigned to sign the paper on that. But for now, I'll leave it as is. And I did say you qualified for the public defender. So any questions? Good luck. Thank you. You are welcome, man. All right, your name, sir?
Antonio Perry.
All right. Mr. Perry, in 2018 CF 11261, you got some failures to appear. And the failures to appear are at a trial management conference on November the 25th. That court, being Division 11, issued a capias and ordered that you be held no bond on the failures to appear. Now, yeah, do you have a private attorney in that case?
Yes, I do. On the streets, I do. Yeah.
I didn't hear you.
I said, yeah, on the streets. I do somebody working my case on the streets.
I still don't know what to say.
He's saying yes, he has a private attorney.
Okay, all right. So you're not asking for the public defender in this case? You're gonna stick with a private attorney?
Yes.
All right. Well, okay. Good luck.
No,
No, you shouldn't talk to me without your
I'm
attorney
sorry,
being
sir.
present.
What I wanted to tell you, reason why I didn't know I had a warrant on me, because at the time I was moving and I was staying at another address, and I didn't know where my mail was going, and I didn't know I had court coming up. And I was waiting on my mail to get forwarded to my new address, but now that where I stay at, I have a address where my mail permanently comes to my door.
Sometimes I suspect that somebody's writing stuff on the wall back there and saying, try this when you go in there because it might work.
You got armed.
It never does.
So
Occasionally it works, but there's not a thing I can do about it, sir. The court that you failed to appear in front of issued a warrant and directed that you be held no bond till you see that judge. So that's what you're stuck with.
So what judge I have to go see?
You need to get your story together, and when you see that judge, you can tell that judge and your private attorney all of that and see what you can work out.
I don't have an attorney. I have this attorney.
He has regional conflict counsel, Your Honor.
Is that who it is?
Yes, Your Honor.
Okay. Well, all right, are you Paul Ruiz? No?
He's mental health, Your Honor.
Mental health? Okay, so, he does qualify for the public defender. So what do you think, counsel? Should we,
I waive his appearance, Your Honor.
Okay. We've got, in 2020 CF 15333, he's charged with possession of burglary tools with intent to use. Never seen that written that way. There's a bond of $1,000, and then burglary of an occupied dwelling unarmed with a bond of $5,000. And as I indicated, he does qualify for the public defender, and his appearance has been waived today by his attorney. So. Might be a what? Oh, let's see. All right, your name, sir?
Emmanuel Rochette.
Okay. You pronounce your last name how?
R-O-C-H-E-R. Rochette.
Rochette.
Yeah, Rochette.
Okay, Mr. Rochette. Let's see what we have here. In case number 2020 CF 15320, you're charged with trafficking in, you want to try that name again, State?
Phenethylamines.
You did such a great job before. And displaying a blank or forged or stolen driver's license or ID is count 2. And then false ID given to a law enforcement officer. Let's see, you do qualify for the public defender, sir, so I'll appoint the public defender to represent you. Finding probable cause for the charges, the bonds are currently set at, the big one is the $50,000 bond on the trafficking charge. And so your bond on the false ID, I'll set at $150, and the false ID given to a Leo, I'll set at $100. Let's see, you are not to return to the Regions Bank located at 2101 East Cimarron Boulevard. You're to have no contact with the witnesses or victims at that location. And that'll probably do it. All right, good luck. All right, good afternoon, sir. Your name?
Good afternoon, Antoine Sanders.
All right, Mr. Sanders, in case number 2020 CF1530880. You're charged with trafficking in methamphetamines, more than 28 grams with a weapon, possession of cannabis with intent to sell or deliver with a weapon, and grand theft third-degree firearm. Let's see, your affidavit of insolvency indicates that you do qualify for the public defender, so I'll go ahead and appoint the public defender to represent you. That's interesting. Trafficking in methamphetamines has a $200,000 bond. The possession of cannabis with intent to sell or delivery with a weapon has no bond. So I'll set a bond on that one at $5,000, and then the grand theft third degree of a firearm at $150,000. So your total bonds are $200,000 on count 1, $5,000 is to count 2, $150,000 is to count 3, sir.
Your Honor,
That's the bond schedule.
yeah, the bond schedule, he's not gonna do it for $20,000. I'll just have, like, wanted to request to see if the court had any objection to lowering the bond amount to $50,000.
State, care to be heard?
Your Honor, just on the say of defense counsel that he's not going to be able to afford it, if defense counsel wants to take sworn testimony from his client and move for a bond reduction, this is the bond schedule.
Right.
Bond. And so if that's what defense counsel wishes to do.
Well, he's on state probation too, so he's probably got some other fish in the fryer that we're not seeing today.
Oh, Your
Yeah. I really don't have a problem reducing the bond to $50,000 because I believe there are other things that are going to tie him up at this time anyway.
Yeah.
And as to the bond schedule, that's a suggestion. It's more for use by corrections than it is by us. So yeah, $50,000 works for me. The other two will stay as I stated.
And
Right.
Your Honor, the only thing is that the state was just requesting that the proper procedure be followed in order to make that request, which has been addressed in the past. That's the only
Yeah, I understand.
question, the only issue that
Heard
the
that
state
before.
had.
But we'll do that. Move on. Thank you, sir.
Okay, so
Mr. Thompson, you know better than that. You know that you can't do that. You have to say, Your Honor, we the court.
All right. Are you William Siegler?
He's medical, Your Honor.
Medical? So, Mr. Siegler, it looks like qualifies for the public defender. How about I appoint the public defender for him? And being as how he's medical, is that one where you would waive his appearance, counsel?
Yes, Your Honor.
Okay. In 2020 CF 15314, A, funny little thing, and O, grand theft third degree of a motor vehicle is a charge. This is pursuant to an arrest affidavit where the signing judge found probable cause and set the bond at, well, $500. So we'll call it $500 in a day. How about Holly Devon Stansel?
Bonded, Your Honor.
Bonded. and Tawanna Washington.
He's behavior.
Behavior, okay. Because of that, I'll find a voluntary waiver on the defendant's part to appear at first appearance. And see what we got here. 20 CF 15346 AO, introducing contraband into a county facility, possession of drug paraphernalia, trespass on property, open container. Bonds are $1,000 on the contraband charge, $250 on each of the other three. I'll reduce those three to $100 each. And then let's see, out on bond on a trespass charge, petty theft, and burglary of a dwelling. Bond amount NA, so that's some sort of diversion maybe? Okay, there is a, I'm not sure what the terms of that person's release is in these three cases they're out on bond on, but I'm going to revoke those terms of release in each of the three cases. Set a bond of $5,000 on the burglary / petty theft charge. That's 154. 5,000. Yeah. And on the petty theft of $100 or more, make the bond 500. That's 6257 transferred to 11445. Does that comport with what you got?
Your Honor, on the 2019 CF 154 case, you said the burglary of dwelling is going to be $5,000. What's going to be the bond amount for the petty theft?
2 counts.
It's 2 counts.
Yeah, $5,000 on the burglary charge, $100 on the petty theft charge.
All right, thank you.
Thank you. And did you figure out that second one?
Yes.
Okay, because there's a third one.
Yes.
2020 MM6693, trespass, make the bond $100 on that one.
And Your Honor, the bond on 2019 11445 was, that was the 6257 was transferred, upgraded to a felony.
Right. Got it.
Was there a bond for that or no action?
Yeah, that was, yeah, 11445. $500.
Thank you.
That was confusing. All right, let's see, your name, sir.
State your name.
Oh, sorry.
Be your master.
Nicholas Butler.
Nicholas Butler, okay. Well, let's see what we got here. In 2019 CF 13862AO, you have a violation of probation. The violation of probation is new criminal offense. Possession of marijuana. Division 17. Well, let's talk lawyer. I don't see an affidavit of insolvency here. Do you have a private lawyer?
I do not.
Do you plan to hire a private lawyer?
If it need be, I'm still confused on what the charges are.
It's a violation of probation on a marijuana charge, or you tested positive for marijuana on 11/16 of this year. So it's a VOP for a positive test.
Okay.
So, do you have a private lawyer, or do you plan to hire one?
Yes, Your Honor.
Okay, so you're going to get your own attorney, because right now you're being held no bond on the VOP. So, What you're gonna have to have your lawyer do is get you set up with a bond hearing on that, okay?
That's not something that could be done today?
No.
Okay.
Good luck.
Your Honor, could we also set a determination of counsel, just in case he doesn't get an attorney in the reasonable amount of
Yeah,
time?
that's probably not a bad idea, set it for a DOC hearing. So,
And he will go before Judge Lattimore within the next week to 10
Yeah.
days, Your Honor.
yeah, probably next week. If we set a DOC hearing, it'll probably be down in courtroom 3 next week.
Next week?
And
Next week.
Judge Lattimore
At the earliest.
will address the
This week is over with.
He goes to in jail January 11th, so.
January the 11th will be the date you appear there, all right?
Okay.
Good luck.
Pardon me now.
Your name, sir?
My name is James Coleman.
Mr.
Pardon me.
Coleman, good afternoon.
Good afternoon, Your Honor.
In case 2018 CF 5363, you're being held on a violation of probation. Violations alleged are failed to pay cost of supervision, new criminal offense, burglary with an assault or battery therein, that's a PBL, and failed to successfully complete 200 hours of community service. Let's see, I don't see an affidavit of insolvency. Do you intend to talk to a private attorney, sir?
If I may address the court
You're gonna
respectfully.
get your own attorney?
Respectfully, sir.
No, I need you to answer
Okay,
my
pardon me.
questions.
I
Do
have
you plan to get your own lawyer?
I have a lawyer. I already have a public defender assigned to me. Richard. I forgot his
this
last
case?
name. In this case,
You're
yes,
just
sir.
now being IA'd on the VOP, so you don't have a lawyer yet in this case.
On the violation of probation, I received mail in Osceola where I was held for 30 days for that crime, the burglary of an occupied dwelling, but that case was thrown out, sir.
Why are you telling me that?
Because I got mail from a public defender for this case. I thought
You did? For this violation?
for this violation, yes, sir.
Well, you're classified as a violent felony offender of special concern, so your status at no bond is undisturbable at this point. Only the court that issues a warrant can talk to you about a bond, so I can't do anything about that today. My hands are absolutely tied.
Even though the case was dropped.
Yeah. State law, violent felony offender of special concern on a VOP, only the court issuing the warrant can address the issue of a bond.
And Your Honor, we do represent him on the violation of probation, and the attorney has been contacted about the situation.
There you go. So, good luck, sir.
Do I have a court date?
Probably not at this point. You may have one in courtroom 3 down there. That same date, maybe? Which was what? January 11th.
Thank you.
You're welcome. I don't know. People tell you they got a lawyer and they don't want you to appoint one. But the PD tells me that the PD's representing them in that VOP, so there you go. What's your name, sir?
Hugo Feliciano.
Hugo Feliciano?
Yes, sir.
Okay. Well, it's a VOP. And the violations alleged, this is what, case number 2014 CF 673AO. Says the violations alleged are you failed to pay cost of supervision, committed a new criminal offense of forgery or counterfeiting, and by viewing, access, owning, or possessing any obscene pornography or sexually stimulating visual or auditory material, blah, 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 blah. Well, now, you're on probation. You're classified a violent offender of special concern. So I cannot address your no bond status today. What I can address is a lawyer. Do you have one?
Yes, sir.
Private lawyer?
Yes, sir.
Okay, to get own attorney. So I can't address the bond. You're going to get your own lawyer. Aside from that, any questions?
When would be the next court date, maybe?
I think this is Osceola stuff, isn't it? Is it?
This is in Orange County.
Yes.
If it's here, it's going to be January 11th in courtroom 3.
Okay. Yeah, because I live in Osceola, but the case is Orange. The case is in Orange.
Yeah. Okay. So you'll be January 11th. You'll be seeing Judge Lattimore down the way.
Your Honor, can you also address that he has reporting requirements?
Yes. You know you have reporting requirements, don't you? You know, have to report changes of address and all that sort of thing.
Okay, well, what about it?
Well, this arrest is considered a change of address. So when you get out of jail, you've got to report this arrest to the appropriate authorities as if it were a change of address. Good luck. Thank you. What do you think? All these people that have reporting requirements to stand there and look blank when you tell them they got them? Like they don't know they got them? Is somebody keeping that a secret from them? It's a conspiracy. I know what it is. Y'all are conspiring to keep that information from them. Let's see. What's your name, sir?
Clifford Jackson.
All right, Mr. Jackson. Give me just a second. Let me sign a couple of pieces of paper here. Okay, let's see, Mr. Jackson, in 2019 CF 11601AO, you got a violation of probation pending. Let's see what that might be.
It appears to be an on view, Your Honor.
Yeah, there are a couple other case numbers in here. Well, I'm going to guess this is what's called an on view because of the new charges. It's an on view violation of probation, and currently your bond is set at no bond on that. You're also because you're classified as a violent felony offender of special concern, that the bond has to stay no bond until you go in front of the judge, either here or the judge that issued the warrant. But, so that's no bond, that'll stay no bond. And you've got some new charges in 2020 CF 15330, Division 14, grand theft, third degree of a motor vehicle, 3 counts of resisting without. Bonds on that are $1,000 on the grand theft charge, $100 each on the resisting. And there's more. You've also got a no valid driver's license. I'll make the bond on that one $100. That's in Division 83. Now, according to your affidavit of insolvency, you do qualify for the public defender, sir. So I'm going to appoint the public defender to represent you on both the VOP and the new charges. Understand? Good luck. Your name, sir?
Salvage Lee, Bernard Key.
What was it?
Salvage Lee, Bernard Key.
Oh, okay. Here's something that seemed, we already did this case, didn't we? Hugo Feliciano? We already did that one? Well, interesting. Okay. Far be it from me not to pass that over to you. That's the case. All right, Mr. Key.
Yes, sir.
Let's see what we got here. It's a violation of probation. And looks like it might be an on-view violation of probation because of new charges, which would be moving traffic violation, driving while license suspended or revoked, third or subsequent violation. So, yeah, it's under a felony case number 2020 CF 15332.
Yes, sir.
And so, yeah, it's what's called an on-view violation of probation, with the on-view being no bond at this time.
Excuse me, Judge. Is it no bond for the VOP or no bond for the driving?
It's for the VOP.
Okay, yeah, of course. Okay.
The driving one is $500.
Okay. And my next question is, that's basically because this is a new case simply because my last charge
You
was
do
dropped.
qualify for the public defender,
Yes, sir.
and I'm going to appoint the PD for you, so you may want to ask the question of the attorney first before you ask me, okay? He's right there next to you. Huh? Yeah, I think it was originally they wrote in 500 and then they submitted this piece of paper and said should be 2,500. But given the fact that he's got the VOP and he's no bonded on that, I'm good with 500. Well, you know, like it makes any difference whether I'm good or not, but you know. So,
I'm good.
got your questions answered?
Yes, sir. I got an answer, sir.
All right. Good luck.
All right. Thank you so much.
Yes, sir. Your name?
Julio Muniz. Sir.
Mr. Muniz, you're in case 2001 CF 16019. A warrant was issued on a violation of community control. That being being away from your residence at hours other than when you were allowed to be.
Yes, sir.
You have not, also, you have not produced any documentation that you're taking your prescribed medications as of 12/17 of 20. Check for the offender's approved resident, take the day off from work, make an appointment with Park Place Residential. All right. And you do qualify for the public defender. Now, that warrant currently has you being held no bond. Trafficking, cocaine. Okay. So I've appointed PD for you. Probably going to see Judge Lattimore next week in courtroom 3 on January the 11th. Good luck.
Thank you, sir.
Let's see, your name, sir.
Brian Matthew Narvaez.
Narvaez. What do we got? State probation. Got a violation of probation in 19 CF 14050. And violations are new criminal offense battery. Yeah. And you do qualify for the public defender, sir. And the judge signing the VOP warrant has ordered you held no bond. So, looks like you qualify for the public defender. So I'll appoint the public defender to represent you, sir.
Okay.
Understand?
Yes, sir.
Good luck.
Thank you.
Good afternoon. Your name?
Tony Palmer.
Ms. Palmer. You're here on a violation of probation in 2019 CF 10359. Violations are committed a new criminal offense, driving while license suspended or revoked. That court issuing the warrant has ordered you held on no bond. You do qualify for the public defender, so I'll appoint the PD to represent you. You're also noted as a violent felony offender of special concern, so I cannot modify your bond today. You're going to stay on a no bond status pending further order of either Judge Lattimore down here or the court downtown, whichever sees this first. Understand?
Yes, sir.
All right, good luck.
Thank you.
Some people just don't look like violent felony offenders of special concern. If somebody come through here that's 4 feet tall, weighs 62 pounds. Well, Steve Zittle.
He refused court, Your Honor.
He did. Well, we'll treat that as a voluntary absenting of himself. He is on state probation. He's a violent felony offender of special concern. Case number is 2019 CF 016123AO. And the violations are... Didn't I see him on another case yesterday?
You did.
I thought I did. Well, I don't have any of the violations. They're all gone. Okay, well, he's no bonded on that anyway. What? Yeah, he refused, so I'm going to go ahead and appoint the PD for him on the VOP. So there you go. That's the week.